I may pardon my lord, weekly list my lord, item number 71. The lordship has already had the matter and directed to file the my lord argument note my lord. I have already filed the argument note my lord. My lord and senior was arguing the matter. Lordship may fix any date so that.
What is this item number?
The vigilance my lord, trap case my lord, only 5 witnesses are there my lord. My lord and senior was arguing my lord.
Who was arguing?
Item 71
Who was
weekly
arguing
list.
from the side of the who was arguing from the side of the vigilance department?
My lord and senior Simon Das was there.
Which item, by the way?
71.
71. May I know the CI number? Appeal number?
The noting is there, lordship may kindly see. Also noting is there in the list.
71 Barclay.
Written argument note has already been filed.
What's up? 16. My lord, if it's the appeal of the year 2016, then in that case, Mr. Maharana will be pressing that matter.
Order sheet the last order.
71. 2016. Lordship may fix any day.
It's mentioned on 1/8/2022. That is the last order, I think. Thereafter, there is no order.
Lordship had fixed a date also. On that date, it could not come in the list, my lord. That is why.
It's all right. Yes.
Lordship, CRL 814 of 2023, press matter, my lord. Vigilance matter, 3 years conviction, my lord. 1 month is completed very next week, my lord.
You want it for admission?
Yes, my admission, press admission. Another is CRL 544 of 2015, my lord. Paper book already received, my lord. It is listed on here.
Pardon to mention, my lord, criminal appeal 160 of 2015, my lord. The appellant in custody near about 10 years, out of 10 years, my lord. He is custody on 5/8/2013.
Give
And
it.
twice in region interim bail.
All right, give it.
My lord, item number 67 of a weekly list, my lord. Kindly delisted, my lord. Kindly delisted, my lord.
Why?
Because conviction is, my lord, 11 years. He is substantial, he is already 11 years, 6 months, my lord. I filed a IA for bail.
So why you want delisted?
Delisted, my lord, it is backward. My item number 24 was there. Thereafter 34. Now today is 67. So
67.
I don't know, 67.
As 67.
My
Then
lord.
how it become delisted?
Kindly be delisted today. My prayer is delisted and my file IA for orders, my lord.
Oh, it is there. When you file it will come with the.
I'm already filed, my lord. IA.
Hmm?
I am filed IA for bail.
What is the IA number?
My lord, IA number 1690 of 2023, my lord.
Which item? 16?
7, my lord.
What is the number of the CRLA?
My lord, CRL number 150 of 2014.
150 of 2014 is item number 64.
Sorry, my lord.
Not 67.
Sorry, my lord.
In this application, in this appeal, you have filed an interim application.
My lord.
What is that IA number?
IA number, my lord, 1690 of 2023.
1690.
My lord.
23.
23.
It's for what? For
It's
bail?
for bail, my lord. I am so interim bail for 3 months, my lord. I am surrendering time, my lord. I am already custody, my lord, 11 years, 6 months, my lord. Substantially.
So when you are granted interim bail?
My lord, I am granted interim bail on dated.
Yes. Next.
Criminal appeal
446 of 2022, my lord.
Hmm.
The petitioner convicted under section 376 AB and continues to undergo RI for 20 years. My lord, I am applied for bail. And another also convicted RI for 14 years, but he is in custody more than 7 years. My lord.
Okay, give it, yes.
20/3/2023 I am granted interim bail, my lord.
So you must have recently surrendered with it.
So already surrendered, my lord.
All right, that's why file your memo, it will
In
come.
criminal appeal, my lord, bail application is
Give
pending.
it.
My lord, weekly 75. Maybe here fix a date to hear the matter.
You wait.
Appellant is a old man, 87-year-old.
It's a vigilance matter.
Vigilance case.
Okay. All right. Wait.
75.
Oh, we'll see that. Yes.
Want to make a mention. Well, item number 40 of your lordship supplementary list. Well, it's a
There is no supplementary list today.
Well, I know, my lord, it was actually listed in other weeks. It was listed at item number 10 and 8.
There is no supplementary list today.
No, I'm sorry, my lord. No weekly list. I'm sorry, my lord.
Yeah.
My lord, item number 40. It's a vigilance matter, my lord. Vigilance matter, my lord.
Yes.
A doctor has been accused of taking 500 rupees, my lord.
Yeah.
My lord, any date, my lord, if your lordship fixes, my lord, we are ready, my lord.
All right, but you wait. If nobody is there, we can take up your matter today.
Gratefully, your lordship. Gratefully.
Yeah.
My lord, may I make a small prayer, your lordship? I mean, basic, your lordship.
Yes.
My lord, item 45 in today's weekly list. This is a matter, your lordship, wherein we have already filed the written note of submission. They will only take hardly 5 minutes. It's a CBI matter. My lord has been pleased to fix it to 6/4/2023 specifically in the supplementary list. But before vacation, your lordship took up bail matter, so it could not be taken up. I pray that your lordship may kindly fix any date on supplementary. Your lordship's convenience, any date in supplementary, my lord.
All the matters.
My lord. Item 45, your lordship.
Yes, noted now.
Weekly list item 1.
Yes.
Once again, I want to draw my lord's attention to the charge sheet framed, my lord. That is in the LCR, probably in page 49. I may be permitted to place the charge sheet.
Paperwork. Paperwork HE. Hello. No. Okay. Yes. Yes. What do you want to show from the charge?
In charge sheet, my lord, my duty has been assigned. What is my duty that has been reflected, my lord?
In the charge?
Yes, my lord, I may be permitted to place, my lord. That Sri Prudanand Sethi was working as postal assistant, Jaspur Road Railway Station Post Office during the period from November 82 to January 94 and was entrusted with the work of deposit withdrawals in respect of SBRD, CTD, etc. Sri AN, being a postal assistant, was looking after the work of head clerk from July 92 to May 94. His duty were to verify the specimen signature of the depositors in case of withdrawals of and above 500. The verification is mainly duty of the head clerk, madam, as reflected in this charge sheet, madam.
You are appearing for whom? That Prudanand Sethi?
Yes, madam. And next para, my lord. Investigation disclosed that there was a withdrawal of so and so amount on 20/10/93 in SB account number so and so standing in name of Arjun Sethi, who deposited this passbook on 8/6/93 with Sri Hudanand Sethi under proper acknowledgement, but Sri Hudanand Sethi and Achyutanand Panda have made payment to one Aruna Chandra Shetty through messenger PK Sethi. This messenger has not been.
What are the charges you were framed that was against you?
Lord, charges has been framed, my lord. 120B, 420, 467, 468, and 471.
120B, then 420, then 468. No.
468 and 471.
468 and 471. That is in internal page 16, my lord, of the trial court judgment.
471. Okay. Then you are, what is the judgment? You are found guilty under which offenses?
My lord, in the last paragraphs on page 16, my lord, the trial court holds that I hold both the accused persons guilty of under section 120B, 420, 468, and 471 of IPC.
What is that judgment? Chalo ye.
Trial court judgment in internal page 16, my lord.
You, hey. Trial court judgment. What is the judgment? That means you are found guilty under all the offenses under which the charge was framed, right?
Yes, ma'am.
So, the cheating, etc., has been done in respect of 4 accounts.
My lord. My lord, let us place the evidence of those 4 account holders, my lord.
PW1, Arjun Sethi.
My lord.
This amount is rupees 8,500. PW2, Janaki Vallabha Pradhan.
6,000 amount.
Amount is rupees 6,000. Then another witness is PW3. His name is Ramakanto Sahu.
2,500.
Rupees 2,500, right? And PW Gangadhar Naik.
5,000.
So total becomes rupees 22,000. So you are pointing out from the charge sheet that your accused petitioner, Rudananda Sethi, he was the postal assistant
My lord.
in Jajpur Road Railway Station Post Office. The period you were there, it's from November 1982 to January 1994. Then the second accused petitioner, Achyutananda Panda. He was the
Head clerk, my lord.
Supervisor, my lord.
okay. He was the postal assistant, but looking after the work of head clerk. Okay. So, all right. Postal assistant. Looking after the work of head clerk from July 1990 May 1994. So as per this charge sheet,
My lord.
you are interested with the work of deposit withdrawal in respect of SB, RD, CTD, etc. And that co-accused, he was to verify the specimen signatures of the depositors in case of withdrawal of and above 500. So obviously all these
Yes.
withdrawals or whatever it may be, those are 500.
Yes, ma'am.
So duty mentioned in charge sheet. All right. So now so far as PW1 is concerned,
My lord.
8,500 stated to have been withdrawn from his account.
Yes, my lord.
And you place the evidence also.
My lord. My lord, but allegation is not against me, my lord. I have not manipulated that signature.
Read the evidence if you
Yeah, my
want.
lord. Yes, my lord.
Arjun
Arjun Sethi. From 1986 to 1993, I was working in the office of Odisha Lift Irrigation Corporation, Jarka. I had one SB account in Jajpur Road Railway Station Post Office, and I was issued with one passbook. I was personally operating the shared account. At the time of deposit, I was handing over the cash along with the deposit slips to accused Rudanand Sethi, who was sitting in the counter.
Just a minute.
Yes, my lord.
All right, you open the paper book. ସେଇ ଯୋଉଟା LCR ଟା ଯୋଉ evidence ଯୋଉଟା read it once again.
From 1986 to 1993, I was working in the office of the Odisha Lift Irrigation Corporation, Jarka. I had one SB account in Jaspur Road Railway Station Post Office, and I was issued with one passbook. I was personally operating this said account. At the time of deposit, I was handing over the cash along with deposit slips to accused Rudanand Sethi, who was sitting in the...
Sethi means it is you. Yes, you are sitting in the counter.
Yes.
And cash is being handed over
Yes,
you
personally,
whenever there is deposit. Yes.
Personally, he has deposited.
Yes, next.
At the time of withdrawal also, I was handing over the withdrawal sleeve to accused Rudanand on 8/6/93. I approached accused Rudanand for withdrawal of amount from my SB account, but he stated that my account has been made silent and the same has to be made up to date only after deposit of the passbook with him, which will be sent to the Jaspur head post office. As per the direction of the accused Rudanand, I handed over my passbook to him, and in token of receipt of the passbook, he granted me one receipt. Exhibit 1 is that receipt. In Exhibit 1, the accused...
Just a minute. So what impression you gave to the PW1 that his account has been made silent?
Yes, ma'am.
The passbook will be sent to
Head post office.
Jajpur head post office.
Ma'am.
And you asked him to hand over the passbook.
Ma'am.
And in token of receipt of the passbook,
Exhibit 1 has been...
You granted him one receipt, that is Exhibit 1.
Ma'am.
Okay. In Exhibit 1, read out next.
In Exhibit 1, the accused Rudanand made an entry regarding the balance of my account, that is rupees 9,928.87. Exhibit 1 was filled in my presence by accused Rudanand.
So, when you handed over that Exhibit 1,
yes,
the witness says that in your own handwriting,
yes,
you have filled it off, that receipt, and by that time the amount which was available in the account of PW1 was 9,928.87 paisa. Okay, continue.
About 1 month thereafter, I approached accused Rudanand about my passbook, but he replied in saying that the passbook has not been received back. In this way, I approached the accused Rudanand for my said passbook. For the last time in the month of December 93, I approached accused Rudanand for my passbook, but he failed to return me. So I went to Jaspur head post office and approached Shujamani Mahanti, assistant postmaster, and reported the same to him on 15/3/94. I reported the matter to Assistant Post Superintendent in writing. Exhibit 2 is my application. At the time of opening my account in the said post office, my specimen signature were obtained in the said post office. Exhibit 3 is the sheet contain my specimen signatures. On 8/5/89, I had deposited rupees 20 in my SB account number so and so. Exhibit 4 is the said deposit slip. Exhibit 4(1) is my signature. I have never withdrawn.
This is most important.
Yes, ma'am.
I have never withdrawn rupees 8,500 on 20/10/1993.
Yes.
Out of my SB account.
Through messenger.
Pramod Kumar Sethi. So you took the passbook in the month of June 1993, and time to time that man was coming to you to hand over the passbook.
And that was
in December 93, he approached you for the last time And when you gave the impression that it has not returned back, then he reported the matter to Assistant Postal Superintendent. So during that period, something has been done, that something is 8,500 has been withdrawn from the account of PW1, and the date is shown to be 20/10/1993
Through Pramod Kumar settlement.
through Pramod Kumar Sethi.
And the
Okay.
Pramod Kumar Sethi has never been.
Okay, put it out. It may be a fake person, who knows. Yes, next.
The signature appearing in the withdrawal slip marked as X is not my signature, and the withdrawal slip is marked as Exhibit 5. There was an inquiry regarding the withdrawals of rupees 8,500 by the postal authority, and during such inquiry my statement was recorded as Exhibit 6 4 sheets in my statement, and Exhibit 6(1) is my signature. During such inquiry, the postal authority obtained my specimen signature in one sheet. Exhibit 7 is that sheet containing my specimen signature. Cross. Mr. One Satpathy had recorded my statement under Exhibit 6 during inquiry. I do not remember the exact date of recording my statement under Exhibit 6 while recording Exhibit 6. No other witnesses was present while I hand over the passbook to the accused Rudananda. I signed in form given by him. It is a fact that I did not state before the IO that whenever I used to deposit, I hand over the money along with the passbook to the accused Rudanand, and at the time of withdrawal, I also hand over the withdrawal form to him. The question under Annexes Exhibit 6 we are prepared by Mr. Satpathy at the right side of corner of page 1 of Exhibit 6. It was first written as Arjun Chandra Sethi by Mr. Satpathy, but he has scored through the word CHA, but he has not put his initial against it. It is not a fact that by submitting withdrawal slip, I have received rupees 8,500 out of my SB account through my messenger Pramod Kumar Sethi. It is not a fact that though I have received 8,500 out of my SB account, I have falsely lost complaint. Against me, only allegations.
Wait. To see your suggestion is that there has been a withdrawal from the account of PW1, and it is PW1 who has sent one person whose name is Pramod Kumar Sethi, and accordingly on the application there has been withdrawal. So if the passbook remains in your possession, you are handed over, that is the evidence, you are handed over the passbook on a particular date. For 6 months that man was coming to you to take return of the passbook. Then in December 93, you are giving an impression to him that the passbook has still not returned from the head office, and in between an withdrawal has been made. So obviously, when the witness is stating that neither he has done it nor he has sent anybody like that man whose name is Pramod Kumar Sethi, now it is your responsibility that to show that how the amount was withdrawn, unless the person himself signs or if it is a case of messenger, then he has to just attest the signature of that person. There is a procedure that also both of you are placing on the other day. Then how you overcome this? First of all, entrustment seems to be there because it was handed over to you. If it has not been sent to the main post office for necessary correction or whatever it may be, then if the withdrawal has been made, then you are to explain how the withdrawal of 8,500 has been made. What is your answer to that?
Well, my humble answer is that promote that usually messengers withdraw the withdrawal money many times, madam, and that Pramod Kumar City has filled up that withdrawal receipt, and
No. If you have, it is your case that PW1 had sent one Pramod Kumar Sethi. So then you should have called for that man that to examine that Pramod Kumar Sethi had come to the office and post office and then withdrew that amount. Now that very document which has been utilized for withdrawing the amount, in that the signature is not telling. That also you are pressing on that day.
Yes, ma'am.
That evidence is of the handwriting expert. I think he has been.
Handwriting expert has not been not sent for a handwriting expert.
It has not been sent.
No, it has
Okay.
been. IO has been stated in his evidence, ma'am.
Okay.
I don't feel it necessary to send.
Just a minute. But it seems that one has stated that my specimen signatures were collected.
No, your lordships, lordships wanted to ask that day what is exhibit 5.1 and 5.2. If your lordships will come to exhibit 5, 5.1 and 5.2. 5, your lordships, indicates that both the accused had passed the withdrawal. 5.1 and 5.2 are the signature of the accused. So even if they have not accepted without admitting,
that is not a not a full signature. It's a short signature. So the question is, who has proved that signature to be of this both the accused?
PW8 has proved now, your lordships.
All right, we'll go to that. We'll go to that. So,
but PW5, exhibit 5.1 and 5.2 are the signatures of the accused.
No, Mr. Naik, it is not the full signature. It's just a short signature.
But those short signatures were
unless a person is acquainted with that. Suppose we also put short signatures, but somebody who is accustomed to that short signature must come forward and say, because when that signature was given, that man was not present. So the person's evidence would be relevant unless if he is either present when the thing was done, the signature was made, or in the due course of business, official business transaction, he was acquainted with our person's signature, and that is how he is identifying. We'll go to that, but is it correct that even though the specimen signatures as stated by PW1 has been collected, it was not sent to any handwriting expert? Is it correct?
That, your lordship, the IO has said in this examination.
All right, I'm noting down it.
We can read the statement of the IO, your lordships, ma'am can.
So, specimen PW1, specimen signatures collected during inquiry. Your contention is that it was not sent to any handwriting expert?
Yes. Para 17 IO has stated.
All right, not sent.
But on the first day when the matter was argued, your lordships,
Yes.
Lordships made an observation that the difference is so remarkable that it is palpably visible in the naked eye. So
No,
therefore,
all
you
right, it has been done. The question is merely because it has been done, unless you prove that it is the accused who has done, you cannot establish his guilt.
no,
So,
accused might not have forged the signature of this Arjun Sethi, but if the accused signature is present in the entire forged document,
no,
then
no,
itself
for that, you see, that is a procedure. Suppose uh, that this present petitioner Hudanand Sethi
yes,
has forged the signature of PW1. If
yes,
that is your case, then the procedure is that in presence of the handwriting expert or somebody, a gazetted officer, that is the rule how you are to collect the specimen signature. In his presence, in that seat, number of signatures uh, of this accused is to be taken, and he is to be be asked to write the uh, um, uh, make the signature of PW1.
yes.
So after that, this
Then you send to handwriting expert.
that is sent to the concerned handwriting expert. So admitted signature of PW1 is there. Obviously,
Yes.
it is in the that postal uh, um, office. It would be there. Then the thing which has been given in the withdrawal is a disputed one. So disputed one with the now it is the sample collection, and it is sent with the for comparison with the original one,
Yes.
and then the report comes. So fact remains that as it appears that
Fact
it
remains is
has
that it was
not been
collected.
sent to handwriting expert.
Yes.
So if it is not sent to handwriting expert, then the question is that the in the withdrawal slip, let us say that there is one signature of PW1.
Yes.
Signature means it appears to be written in the that Ajib PW1 has put the signature, and PW1 himself was confronted whether where is that line, whether he was shown that withdrawal slip. Withdrawal slip X is not my signature. So withdrawal slip is marked as Exhibit 3. In paragraph number 2 of PW1, he says
Exhibit 5.
that withdrawal slip, that is Exhibit 5, okay. Withdrawal slip Exhibit 5 रे जो signature अछि, which has been marked as X, is not my signature. So witness has stated so. Now handwriting expert and what the suggestion has been given that it is actually his signature, and in addition to the signature of PW1, there is another signature of one Pramod Kumar Sethi, who is stated to be the messenger of PW1, and he was perhaps sent to the post office for this withdrawal purpose.
Yes.
So Pramod Kumar Sethi has not been examined in this case.
Either by us or by them.
Right. Nobody knows that whether any such person is in existence or not.
Yes.
So ultimately, if it is your duty as the prosecution to prove your case beyond all reasonable doubt.
Yes. Also, there is no dispute.
So, if we analyze the evidence of PW1,
Yes.
then what it appears that passbook was handed over to him, to this particular accused.
Yes.
In June, and impression was given that it has been sent. Have you verified from the head office? Is there any evidence that from the head office it was verified that in fact this particular passbook of PW1, which is allegedly received on 8/6/1993, has not been sent there for any purpose whatsoever? Because the impression that was given that that is in chief examination PW1 8/6/93, when I approached for withdrawal of the amount, he stated that the account has been made silent and the same has to be made up to date. Only after deposit of the passbook with him, which will be sent to Jajpur head post office. Very categorical statement he has given. So, whether passbook of PW1 has been sent to Jajpur head post office. This is a vital thing, because it is you who are to collect the material in that respect. Because the witness is saying that I have handed over this passbook to the accused on 8/6/93. Impression has been given by the accused that it is to be made up to date, and only the same can be done if it is sent to the Jajpur head post office.
Yes.
So, prosecution's duty in such a situation, or the investigating officer's duty in such a situation, was to approach the postmaster of that Jajpur head post office and to verify whether any such passbook of PW1 had come from 8/6/1993 till that day or not. So, what is the evidence of the IO in that respect?
My lord, IO has
Whether
not,
he had gone to the Jajpur head post office at all,
no, my lord.
where he has stated that he has not gone. Who is the IO?
My lord, IO is PW9, my lord.
Just a minute. PW9 IO, first show me that where he has stated that the documents were not sent to handwriting expert.
Para 17, my lord.
Para 17, just a minute, let me see.
It was not necessary.
Wait. Para 17. ଏଗୁଡ଼ା ଯେମିତି ଲିଭିବନି ହେଲା. It was not necessary on my part to send the disputed. Okay.
To handwriting expert Calcutta for examination
Okay.
and opinion, since the same was already attended by the postal department.
Okay. So, not sent to handwriting expert. It comes from PW9 para. It is 17. Okay. Now, he is the sole investigating officer or anybody else is there?
No, he is the sole investigating
So,
officer.
has he not stated that he had ever visited that Jajpur head post office?
No, he has not stated about that.
Let us see that evidence.
We can read the evidence from the beginning so that.
Please read it from the beginning.
Yes, my lord. PW9 Gopabandhu Patti. I was working as an inspector CBI BBSR during the period from 9/7/89 to 24/1/2000. On 8/2/94, I registered CBI SPE Bhubaneswar case number so and so against Sri H.N. Sethi and others under the order of special CBI Bhubaneswar and took off investigation. This is the said FIR marked as Exhibit 56 and 56/1 is my signature therein. During the course of investigation, I have seized the documents by sigil list dated 10/8/94, Exhibit 26, on production by Sri Satyavrat Satpathy, and this is my signature therein. Exhibit 26 to also seized. I seized some more documents by sigil list. Exhibit 28 and Exhibit 28-2 is my signature therein. I also seized 3 more documents by Exhibit 27, wherein Exhibit 27/2 is my signature. I seized 1 more documents by Exhibit 23, wherein Exhibit 23/2 is my signature. I have seized 1 receipt dated 25/4/94 on production by Sri Gangadhar Naik. This is the shared seizure list. Exhibit 57, wherein Exhibit 57/1 is my signature. During investigation, I have examined the witnesses, namely Sri Satyavrat Satpathy, Gangadhar Naik, Lakshminder Kaur, Ashok Kumar Naik, Muralidhar Satpathy, Narayan Chandra Behra, Janaki Vallabh Pradhan, Ramakanta Sahu, and Arjun Sethi, and recorded their statement under Section 161 of CRPC. After investigation of the case, I placed charge sheet against Sri Hudanand Sethi and Achyut Panda under Section 120B, 420, 467, 468, and 471 IPC to face their trial. Investigation in gist transpires that the accused persons mentioned above conspire with each other, and in pursuant of their conspiracy, they cheated the account holders, namely Sri Janaki Vallabh Pradhan, Gangadhar Naik, Ramakanta Sahu, and Arjun Sethi in them after of withdrawal of money from their accounts. Cross. Para 9. I have not cited the Superintendent of Post Office Northern Division Cuttack as one of the CS witnesses who has submitted the inquiry report by Exhibit 53. I have examined Suryamani Mahanti and K.C. Hota, but I have not cited them as CS witnesses. I have not cited Superintendent IP Jaspur Road, SBM Jaspur, and DDAP Jaspur Road as witnesses. I have not examined the above 3 persons. The accused persons have deposited the defraud amount, and as such, there is no loss to the department during investigation. It could not be established who had forced the signature.
This is important line. During investigation, it could not be established who had forced the signature of the depositor. Okay, continue.
Exhibit 3 in SP 42/94 reveals that Gangadhar Naik, the depositor, had given in writing on 25/4/94 that he had engaged K.C. Mahanti as messenger to withdraw the amount in RD account number 11508, and he received the amount rupees 10,831. Exhibit 3/1 SP 42/94 is the signature of Gangadhar Naik. It is not a fact that PW4 has stated before me that he granted the receipt on 25/4/94 and appointed K.C. Mahanti as messenger to withdraw the money on his behalf. My investigation is silent regarding some overwriting in Exhibit 32 and 33. I have not examined Hrusikesh Patra. It is not a fact that I did not examine the witnesses who did not support the prosecution case. Achyutananda Panda has not signed in Exhibit 15 for Ramakanta Sahu. It was not necessary on my part to end the disputed writings to handwriting experts Calcutta for examination and opinion since the same was already attended by the postal department. It is not a fact that I have submitted false charge sheet at the instance of CBI. It is
Okay,
not a
so,
fact that accused
right.
persons have not.
So that means he has not made any statement to have gone to that Jajpur head post office.
My lord.
So that particular passbook of PW1, which was handed over to the Surdananda, accused Surdananda, on 8/6/1993, stated to have been handed over, and Exhibit 1 is that received. Query that passbook, whether that passbook has been produced
that has
in
not
court.
That has not been exhibited. That has not produced.
Okay. Passbook of PW1 not produced in court, not seized by IU. Okay. Mr. Nayak.
Yes.
You see, so many lacunas are there. We are focusing on this particular evidence of PW1. If Exhibit 1 is that received, which shows that this particular accused has received the passbook,
yes,
and gave the assurance that it will be sent to Jajpur head post office,
yes,
whether it was not the duty of the prosecution or the IO to visit Jajpur head post office, collect information from the head postmaster that whether any such passbook had come at all
yes,
to the head post office for making it up to date, and whether it was not required on the part of the prosecution to seize that very passbook which was of PW1, which was handed over by virtue of Exhibit 1 to him. So in that respect, at least some investigation should have been conducted. Suppose a document would have come from that head postmaster of Jajpur post office that no such passbook had ever come, or PW1 had ever come to the head post office for making it up to date. That evidence would have gone against this man.
yes,
As an then number two, if it says no, then the accused should have been confronted. Now you received this passbook as it appears from Exhibit 1, and you gave this assurance to him that it will be sent to head post office for making up to date. The head post office, the postmaster says that it has not gone there. Where have you kept the passbook? So it should have been confronted to him, showing the letter of the head post master. So that has not been also done. Neither that passbook seized nor these things which were required to be done in a case of this nature. That has not been done. And more particularly, the IO make a damaging statement that during investigation we could not know as to who has forged that signature. Then how you will say, if your IO saying that we do not know, I do not know during my investigation, I could not know that who has forged the signature of this PW1 in the deposit slip. How you say that it is the accused who has done? On what basis?
Your Lordship, my respectful submission before the Honorable Court is that this question was also asked on the last date of hearing. Your Lordship was of the view that Exhibit 5.1 and 5.2, which are the short signature of both the accused,
Again, you are relying on that short signature. Come to the evidence of that gentleman who has proved
PW8.
it. PW8. Right. Read that evidence entirety.
Yes.
Let us go to.
And Your Lordship, Section 46 of the Indian Evidence Act is applicable both for short signatures and also.
No, it's all right. But somebody must be acquainted.
He is acquainted, Your Lordship, because Your Lordship he has stated it.
Acquainted mane khali acquainted kahidele habani. Mane there must be evidence how he got acquainted. ମୁଁ ଯଦି କହିବି ମୁଁ ଆପଣଙ୍କ ସିଗ୍ନେଚର ସହିତ acquainted, short signature ସହିତ, but I cannot say that କେବେ ମୁଁ କେମିତି acquainted. So that evidence must also be brought on record, and so that the court will be satisfied. Yes, on number of occasions during this official transaction, some documents signed by with short signature came to me, signed by you, came to me, and that is how know that it is the short signature of Mr. Sarthak Naik. If that is not there, that evidence I am acquainted with, then it is your duty that to prove that how he got acquainted. Let us first see that evidence.
But acquainted with signature is not there.
Let us see that.
Yes, my lord.
Please.
My lord, I was working Satyabrat Satpathy, PW8. I was working as Assistant Superintendent of Post Office, Cuttack North Division, Cuttack from February 91 to May 95. Jaspur Road Railway Station, Shop Post Office was under my administrative jurisdiction. At that time, Achyutananda Panda was working as Supervisor of Saving Bank branch of Jaspur Road, Shop Post Office. I knew Rudanand Sethi and Achyut Panda and Sri K.C. Manti at the time. They were working as postal assistant of Jaspur Road, RS Sub Post Office, office head clerk, supervisor of SB branch Jaspur Road, Sub Post Office, and authorized saving bank agent of Jaspur Road, Sub Post Office, respectively. 2. As directed by the Superintendent of Post Office, Cuttack North Division, Cuttack, I conducted an inquiry into the allegations made by some depositors of Saving Bank and RD account at Jaspur Road, Shop Post Office. As codified in the Postal Manual, the procedure for withdrawal from SB and RD account is that the depositor should submit the applications form for withdrawal along with the passbook at post office.
First of all, Mr. Naik,
yes,
this you see this statement where he was working as the Assistant Superintendent of Post Office, Cuttack North Division, Cuttack, from February 91 to 1995. So during this period, he was the Assistant Superintendent of Post Office and working at Cuttack. At that point of time, it was undivided Cuttack. The that means this
Jajpur was inside Cuttack.
Yes. Even if at that point of time appeals were filed, criminal appeals were filed in Cuttack District Court in the case of conviction in Jajpur, Jagatsinghpur, Kendrapada, all these things, Cuttack it was filed, and then it used to be transferred till that went on till it became the separate district, and separate district judges were appointed. So this period, this man was working on Cuttack. The post office is at Jajpur Road, and in that Jajpur Road, these two accused persons were working. One was working as a postal assistant. The other was the head clerk, right? Now, continue then.
Yes. As codified in the postal manuals, the procedure of withdrawal from SB and RD accounts is that the depositors should submit their application form for withdrawal along with the passbook at post office counter. The concerned saving bank postal assistant should scrutinize the application form, examine the specimen signature of the depositors in application form, and compare the same with the signature in the specimen signature book, and on satisfactory certification of the specimen signature, he will allow the withdrawal. In fact, he should make necessary entry in the application for withdrawal and also make necessary entry in the concerned SB or RD passbook, authenticate the entry by putting his initial and date stamp of the concerned office, and return the passbook to the depositors with the required amount of withdrawal. Thereafter, he will prepare a list of transactions made by him during the entire day and submit all the applications for withdrawal and pay-in slips to the head post office along with the daily account and list of transactions. The postal assistant should also make the amount of withdrawal in the sub post office along with and sub post office ledger to confirm the entry of the amount of withdrawal in the appropriate records. In this way, a withdrawal is allowed. In some cases, withdrawal is allowed in respect of saving bank account and RD account through messenger, but messenger serving is not allowed in respect of final withdrawal from the RD accounts. The procedure is that the depositor should attest the signature of the messenger in the application side of the application for withdrawal.
Just a minute,
In RD account, messenger is not allowed.
just a minute. You are reading from paragraph number 5. In some cases, read it once again.
In some cases, withdrawal is allowed in respect of saving bank account and RD account through messengers.
This is a case of messenger service has been utilized, right?
Yes, ma'am.
Okay.
But
messenger service
is not allowed in respect of final withdrawal.
So it is not a case also of final withdrawal because the amount which was there in 9,000 some odd and
9,900.
what was withdrawn is only 8,500.
It
So it's not the final withdrawal.
It is a SB account. That is not RD.
Which one?
That is PW1's account.
Okay. In respect of saving bank account, yes. Then
the procedure is that the depositor should attest the signature of the messenger in the application side of the application for withdrawal. The postal assistant who deals with the withdrawal should verify the specimen signature of the depositors in the application for withdrawals, and if he is satisfied with the genuineness of the messenger, he may allow withdrawal to the messenger. When an unknown person comes to the post office being deputed as messenger or by the depositors, the genuineness of the messenger should be verified by the postal assistant before allowing withdrawal. In my presence, seizure lists were prepared by the CBI people, and Exhibit 25 to 28 are the said seizure list, and Exhibit 25(1) to 28(1) are my signatures. Show also the specimen signatures of Hrudanand Sethi were obtained in my presence by the CBI inspectors. 5 sheets by Exhibit 29 to 29A and Exhibit 29(5) to 29(9) are my signatures. On 14/6/93, Sri Gangadhar Naik, depositors of RD account number so and so, had not submitted any withdrawal form to the post office for taking loan from his.
No. You come to this particular witness. His name is PW1 is Arjun Sethi.
Yes.
Let us come to that because we are focusing now on PW1's evidence. Oh, about that, what is the chief examination? Because it may be in respect of some other depositor. Gangadhar Naik is PW4.
Yes.
Please focus on this PW1's se tari bisare se kon kohuchi. Paragraph re PW1 Arjun Sethi ro withdrawal विषय बा से document गुड़ाक विषय which paragraph please?
That is 17.
17.
All right. 16.
Okay, 16. All right.
16.
Let us come. 16 1 Arjun Shetty. Okay. Similarly one. All right. Please place it.
Similarly, one Arjun Sethi had opened an saving bank account number so and so at Jaspur Road Post Office. When the passbook concern was received from the depositor, Exhibit 3 is the specimen signature of Sri Arjun Shetty taken at the time of opening of the passbook. On 20/10/93, an amount of rupees 8,500 has been withdrawn from SB account number so and so standing in the name of Arjun Sethi. Exhibit 5 is the said withdrawal form. On inquiry, it is revealed that the amount of 8,500 has not been taken payment of by the depositor. It is also seen from Exhibit 5 that one Sri Arun Chandra Sethi has applied for the withdrawal, citing one Sri Pramod Kumar Sethi as messenger. And
Just stop. It is also seen that Exhibit 5, that one Arun Chandra Sethi has applied for withdrawal, citing so and so Pramod Kumar Sethi as the messenger. And Pramod Kumar Sethi has put his signature in the withdrawal form. All right. Yes, read it.
The withdrawal was passed by both the accused.
This is the most important statement. The withdrawal was passed by both the accused, Udanand Sethi and Achyutananda Ponda, and Exhibit 5/1 and 5/2 are the signatures. So he makes a statement, positive statement, that this withdrawal slip. Yes, Mr.
Lordship, in cross-examination.
Cross-examination. No, this is not cross-examination. This is, I think this is not the cross-examination. This is chief examination. It is going on in each account. The questions are being put by the public prosecutor. Rightly, it has been done. So he makes a very categorical statement in paragraph number 17 that the withdrawal form is relevant. Withdrawal form is Exhibit 5. So far as just a minute, let me take note of it. So Exhibit 5 is the withdrawal form in respect of the account of PW1, right? Now he says that withdrawal was passed
by both the accused.
And Exhibit 5/1 and 5/2 are the signatures of Udananda and Achyutananda. Okay. So please then continue.
Para 18. At the time of inquiry, I have obtained the signature on the reverse side of Exhibit 5, which is marked as Exhibit 5/3. I have examined Sri Arjun Sethi with reference to Exhibit 35 and taken his statement by Exhibit 6, the questionnaire form. This is my signature therein marked as Exhibit 6/3, and this is the signature of Arjun Sethi marked as Exhibit 6/4. During my examination, Sri Sethi denied to have applied for the withdrawal and also denied to have put his signature in Exhibit 6. This is the ledger card in respect of SB account number standing in the name of Arjun Sethi, which is.
So this Arjun Sethi was also examined during inquiry, and he denied his signature in Exhibit 5. Not only he denied the signature during inquiry, but in court also, he said that X is not my signature. X was confronted to him. So withdrawal slip in that signature, he says that it is not of mine. So now Okay. Now continue.
This is the ledger card in respect of SB account number 1324111 standing in the name of Arjun Sethi, which is marked as Exhibit 34. The withdrawal of 8,500 on 2010-93 has been incorporated in the said ledger card via Exhibit 34 by 1. Our post office also maintains daily list of transactions of withdrawal and deposits and submits the same to the head post office. Exhibit 35.
So just a minute. So date of withdrawal is 2010-1993. So apart from the withdrawal slip, where this amount of rupees 8,500 has been mentioned, there is also mention in the ledger card.
Yes.
Ledger card in respect of account of PW1 also by the Exhibit 36 also shows withdrawal of rupees 8,500 on 20/10/1993.
And Exhibit 40 is the daily transaction list.
Huh?
Exhibit 40 is the daily transaction list.
40 are the list. Acha. Exhibit 40 is the transaction list dated 20/10/93. Exhibit 40 is the transaction list dated 20/10/93. All right. Now you come to continue. Next.
Our post office also maintains daily list of transactions of withdrawal and deposits and submit the same to the head post office. Exhibit 35 is the list of transactions dated 14/6/93. Exhibit 36, 37, and 13 and 39 and 40 are.
We are concerned with 40. So far as evidence of PW1 is concerned, that relates to that Exhibit 40, because that is the transaction dated 2010-1993 respectively, on which date this Exhibit 5 is stated to have been prepared and some signatures are appearing. Okay, now you come to paragraph 20.
There is no transactions in the passbook of account number 11569 marked as Exhibit 13 on 17/1/94. This is the pay slip in respect of deposit of rupees 2,762.50 in the RD passbook number 11569 towards payment of loans.
We will not. We just want to skip this. Now let us mark this particular SB account is PW1 is SB account is 13241. All right. তারপরে এই particular passbook সংক্রান্তীয় further examination ରେ କଣ ଅଛି ଦେଖାନ୍ତୁ। এটা ହଉଛି ଅନ୍ୟ account ର ଯୋଉ paragraph 20 ଟା ଛାଡି ଦିଅନ୍ତୁ, skip it over. Then 21 ରେ କଣ କଲା? Report of the statement. So and so. These are the SO daily accounts of Jajpur so and so. We are concerned with a particular date, that is 2010-93. That is also there. Daily accounts. There are SO daily accounts of so and so. By Exhibit 42.
There is nothing reflected regarding that passbook, madam.
No. Daily account रे ଆସିଲା या number ଟା ହଉଛି ଏଟା ହଉଛି 20/10/93 ତ ହଁ 20/10/93 ତା ମାନେ there are issue daily accounts. Daily accounts dated 20/10/93 এটা মার্ক হচ্ছে 1 2 3 4 তো 42 43 44 45 it is exhibit 45 right exhibit 45 that is PW8 para 22 এটা যে কইছিল 40 এটা হচ্ছে PW8 para 19 okay পড়ুন
My lord, in para 31, PW8 stated that I was not acquainted with the handwriting and signature.
come to the which one
My lord,
ଆମେ କୋଉଠୁ ବର୍ତ୍ତମାନ ପଢୁଥିଲୁ
ଆମେ para 20 ରେ ଥିଲୁ
20 ରେ ଥିଲୁ
ଆଜ୍ଞା
ହଁ 20 ଟା ଛାଡି ଦିଅନ୍ତୁ ସେ ରିଲେଭେଣ୍ଟ କିଛି ନାହିଁ 21 ଦରକାର ନାହିଁ ଦେନ୍ 22 ଗଲା
26 ରୁ
20 ରେ ଆସି ଯାଉଛି ଏଇଟା ହଉଛି ଆଇଟମ ନମ୍ବର ଡେଲି ଆକାଉଣ୍ଟ ହଉଛି 20/10/93 ହଉଛି 45 ଆସୁଛି କାରଣ 42 43 44 45 ଏଇଟା ସିରିୟଲି ଗଲେ 1 2 3 4 ଟା 4 ନମ୍ବର ଆସୁଛି 20/10/93 ତେଣୁ 45 ଆସିବ alright then what else he has stated
26 paragraph, Your Lordship. I have
26 20 I have recorded the statement of Hudananda Sethi the accused in question answer form on so and so the said statement in 16 sheets marked as exhibit 51 so exhibit 51 is the statement of petitioner
And Your Lordship may note that in that exhibit 51 and 52, they have stated that the signature of Arjun Shetty doesn't tally with the signature put in the withdrawal slip, both of them.
out of which exhibit 52 is the statement of Achyutananda Panda.
And both of them had admitted in 51 52 that the signature put in the withdrawal slip doesn't tally with the signature of Arjun Shetty.
କୋଉଠି ଅଛି
ସେଟା 51 and 52 ରେ ଅଛି
no ନାଇଁ ଇଏ ତ କହିଲା paragraph 26 ରେ କହିଲା I have recorded the statement of Hrudananda Sethi
ସେଟା କହିଲା
in
ସେ ଯୋଉ
question answer form and it is in 16 sheets ଏଇଟା ହଉଛି Hrudananda Sethiର signature
So Lordship will peruse that exhibit 51 and 52 ତା ଭିତରେ ଯୋଉ question answers ଅଛି inside that they both have stated that it doesn't tally.
Okay. So we'll go to that.
Yes.
So I have recorded the statement of Achyutananda Panda. It has 52. Then inquiry report asila. Copy of the letter in which certain documents relating to so and so. Some documents were also sent. This para 29 he has stated. PW 8 in para 29. Some documents sent to GEQD for export opinion. Okay. Continue.
So para 30 is saying that GQD Kolkata Video Exhibit 55 has submitted this letter to the Superintendent of Police. So what is Exhibit 55 is?
Exhibit so-and-so. By the exhibit has submitted this letter to so-and-so. कौन लिख रहा था? फिफ्टी फाइव टा देखिला कौन अछि एग्जिबिट
55 and
लिस्ट टा
54. Because if it is sent to the GQD, Your Lordship, we can see the questions.
55 टा
55 and 54 both. 54 are questions and 55 are answer.
wait. Hey, बार कर लो 55. Scroll down.
This is a copy of the letter. This is the letter.
पाइलो रो 55 टा तो अच्छी कौन तार ओपिनियन कौन आसला हैंडराइटिंग एक्सपर्ट ओपिनियन तो अच्छी मना कौन कर
आयु कहिছে ନା
आयु कहला जे मु हैंडराइटिंग ओपिनियन एक्सपर्ट नहीं नथिली because post office has sent it. If your lordship will analyze this,
जहाँ भी हो माने पोस्ट ऑफिस रो जो ओपिनियन से पठेइतला PW8 रो से
PW
कोशी
54 टा पढो तादर क्वेश्चंस गुडा भी अछि को डॉक्यूमेंट बे सेंट
क्वेश्चन गुडा को अछि एवं आंसर गुडा को मध्ये अछि
दैट
प्रथम
शिशुरा पॉइंटेड
क्वेश्चन होछि हमर ए जो एटा admitted specimen signature slips of Arjun Sethi.
Yes.
Arjun Sethi means PW1. Collected from specimen signature book available in the Jajpur Road and pasted to a piece of paper are marked as exhibit A1 and A2. Achha. So it is A1 and A2. तापरे हला admitted writings and एटा होची specimen जोड़ा available थिला post office पाकरे. Then admitted writing and signature of Arjun Sethi in passbook number so and so found in the paying slip dated so and so submitted at Jajpur Road with a deposit of rupees 20 in the aforesaid passbook is marked as exhibit A3 by A4. Admitted specimen signature of Gangadhar Naik. We are not concerned with Gangadhar Naik. Now, what are the so गोटे हला A1 A2 एटा होची से जो specimen तापरे admitted हसला A3 and A4. वर्तमान आंसर देखिवा नहीं क्वेश्चन होची whether the signature appearing at B1 is the signature or of the person who put his signature on so and so, so and so. So, ये कला ये काटी दिया मैंने से जो ये टा काटा तो ताऊ पटे काटा. What is this B1? Whether the signature appearing is the writing of the person who the person who wrote the enclosed signature stamped and marked as S1 to S14 and A1 to A4 did not write the enclosed signature stamped as Q1. ତେଣୁ ସେ ଯୋଉ withdrawal slip ରେ ଯୋଉ signature ଟା ଅଛି ତାକୁ ମାର୍କ କରିଥିଲେ Q1 ରେ ହିସାବରେ ଆଉ S1 S2 S14 ହେଲା sample signature ଆଉ A1 to A4 is the admitted handwriting of that man. City. Okay. So exhibit 55. Questions and Answers. तो जो हैंडराइटिंग एक्सपर्ट रो जो ओपिनियन आसिला से ओपिनियन नु जा जना पड़ला जे PW1 withdrawal form fill up करिनी माने जो सिग्नेचर टा अछि सेटा तार सिग्नेचर नै कारण तार जो सैंपल सिग्नेचर थिला पोस्ट ऑफिस रे ताकू कलेक्शन हला प्लस तार एडमिटेड हैंडराइटिंग कलेक्शन हला कलेक्शन हेइकिनी पठा गला एवं रिपोर्ट आसुची जो सिग्नेचर टा जोटा अछि विड्रॉल स्लिप रे जोटा को गोल बुलाई किनी मार्क हेछि Q1 so that is not the signature of this PW1 जदि PW1 रो सिग्नेचर सेटा नुहे ताले अन्य जने किए PW1 हिसाब रे साइन करछि से जनक किए
ताकू से माने वेरीफाई करके निज दस्खत भी मारचंती
हाँ सी जो वेरीफाई करिकिनी सी जो आपण ताकू दी जन जाको कहउचंती जे एटा होची तारो सिग्नेचर
आ पैरा 8 रे से पूछे जे आई एम एक्वाइंटेड विद एंड फर्दरमोर यू
9 ना कोन आईओरो 9 ना 8 हाँ 8 रसी जो पढ़ा होतला जोटा ताकू जो मार्क करिकिनी से कहलानी
In para 32 that PW8 stated that I have not acquainted with the handwriting.
wait just a minute ए जो दीटा सिग्नेचर आसिला से कहलानी पैराग्राफ नंबर 17 ने जे एग्जिबिट 35/1 एटा 35 नो एटा 5/1 हो 5/1 and 5/2 are the signatures of Rudanand Sethi and Achyutananda Sethi specific statement दापरे आपण कोन क्रॉस एग्जामिनेशन बाहर करछन देखिबा
ने पैरा 32 रे से कोनी जे आई एम नॉट एक्वाइंटेड विद द सिग्नेचर ऑफ रुदानंद
पैरा
सेठी
32 देखिबा नै टिके देखिबा कोन से कहउछन पैरा 32 हां पढंतु कोडा आपण
I
पढियो
could not ascertain who had signed in the withdrawal form in the name of account holder. I have not ascertained whether those handwritings and signatures in withdrawal forms belong to the accused persons or not. After inquiry, I came to the conclusion that the withdrawals were fraudulent ones. I have mentioned in my report Exhibit 53 that H.N. Sethi, A.N. Panda and K.C. Mohanty committed fraud in respect of withdrawal of money. I have mentioned in my report 53 at page 5 in para 2 that previous conduct of A.N. Panda to verify and scrutinize the genuineness of the signature of the depositors on the withdrawal form with the specimen signatures. The A.N. Panda is authorized to verify that signatures, to compare that signatures. And in this case, regarding the
I
present,
mentioned in my report that so committed fraud. Okay, I have mentioned in my report previous one. It was the duty of the accused. A line ta कहउछन it was the duty of the accused A.N. Panda to verify and scrutinize the genuineness of the signature of the depositor on the withdrawal form with the specimen signature.
And that is also reflected in the charge sheet also, the duty of the head clerk and specifically he is stating that in this paragraph he is not acquainted. He couldn't. I have not ascertained whether those handwritings and signatures withdrawal forms belong to the accused persons or not.
No, what Mr. Naik is pointing out when in the chief examination he has stated that this is the particular, this two signatures which are
In paragraph 8, he's saying that I'm acquainted with the handwriting. Your lordship asked me a question whether he was acquainted or not, and that has not been shaken in cross examination. In paragraph 8, if your lordship will come to paragraph 8 of the examination in chief, PW8, paragraph 8, examination in chief, dated 27/3. Your lordship's last two lines. I'm acquainted with their handwriting and signatures. Exhibit 31 and 30/2 are their signatures.
30টা কোন ডিটেইলস এটা পুরো গঙ্গাধর নায়কর
नहीं गंगाधर
এটা গঙ্গাধর নায়ক अकाउंट we are not concerned
नहीं
with
I am
now.
talking I am only pointing out the जहां भी अकाउंट हेले भी ताको सिग्नेचर सेथरे अछि बोले अछि गंगाधर केस रे कहिछि. It meant the question was about the identification of the handwriting in the sleeves. Gangadhar case रे कहिछि, but it is also acceptable to the whole case, your lordships.
Acquainted with their signatures and handwriting exhibits. That was also allowed by swans. Okay.
It can't be a coincidence, your lordship. It is happening with everybody. जनकर हितला हम कहथन बाय चांस भूल गेला. The modus operandi is same for all the accused, your lordships.
Okay, so now we are in which page? Page number. You are in page number. That is paragraph number. Who paragraph place করছিলে?
I was placing my lord paragraph 32.
Just. Have you given any suggestion to this witness that you are not acquainted with the
no suggestion
signature of these two accused persons, and these are not the signatures of these two accused persons? Specific dita ପ୍ରଶ୍ନ ପଚାରୁଛି ଯେ ଗୋଟେ ହଉଛି ସେମିତି କିଛି ପଚାରୁଛନ୍ତି ଦେଖିଲେ କାରଣ ଖାଲି ଗୋଟେ 32 paragraph ଟା ଆପଣ କହୁଛନ୍ତି I could not ascertain who had signed the withdrawal form in the name of accounts holder. Signature यार मानेटा होची कोन एई जो लाइन टा पचारले जे किए दस्तखत कला सेटा से कहि परिबन. That is not relevant. Relevant is that you have passed it.
You have passed it with your signatures, your lordships.
मने करंतु कोनोसी पोस्टल स्टाफ भी ताकू करिनी गोटे बाहर लोक जरिया रे से माने दी जण ताकू करि आछन जोटा कि संभव हलानी इन्वेस्टिगेशन स्टेज रे बा इंक्वायरी स्टेज रे धरिबाकू जे प्रकृत रे एथरे सिग्नेचर टा किए करिछि ए जो PW1 ना रे बा 1 रो सिग्नेचर किए करिछि. But now you are the two persons, one is sitting in the counter who is receiving it, the other man is in charge of verifying with reference to the postal documents where specimen signatures are available. तेणु जणे सेटू रिसीव कला परे से ताकू विड्रॉल स्लिप टा पासबुक सहित पठेइबो ता पाकू पोस्टमास्टर वेरीफाई करिवो से खाता कढाबो देखि दबो जदी ओके अछि ताले पोस्टमास्टर सिग्नेचर हेबो तापर जाइनी ये आपको फेरी आसो ये टंका दबो जे काउंटर रे बसछि. दिस इज द जनरल प्रोसीड्यूर. तेणु वर्तमान होउछि मने करा जाऊ जे विड्रॉल स्लिप रे कहार माने किए PW1 हिसाब रे साइन कला से एविडेंस आईओ जानी परलानी जे वेदर इट इज XYZ किए कला से जाना परलानी. बट फैक्ट रिमेन्स दैट सी विड्रॉल स्लिप को व्यवहार करा जाई टंका विड्रॉ हेछि PW1 रो अकाउंट को 8500 टका एवं ताकू आपण दुई जण ही पास करछन्ती अर्थात दी जण दीटा पिटिशनर. वन इज इन दी काउंटर रे बसछि अनदर इज दी मेन ऑफ हेड क्लर्क.
Yes.
तेणु एठी हाउ डू यू say that there is no liability on you, or you have not done it, or anybody XYZ has been done it.
Admittedly, I am a head clerk and supervisor.
Head clerk, the duty has been assigned that you are to verify it. That is in the charge sheet also. They have also mentioned that Mrs. Panda's client is used to receive that same and the passbook, etc. But your duty is to verify the specimen signature, because ordinarily the specimen signature, etc., those documents are available with the postmaster. So postmaster used to find out, and if he says okay, it's all right, then amount will be paid. Any case of doubt, then the person concerned is required to be put another signature. Suppose some kind of variation is there, or any other proof to show that he is that person. Like nowadays, of course, it is there that ID card is there, but at that point of time, it was not there. This voter card, this Aadhaar card, obviously, those were not there. So the method which they were adopting, that put another signature. So in case 2 or 3 signature, he becomes satisfied, then clears that. But here, as it appears that it is the duty of A.N. Panda. A.N. Panda is your client, to verify and scrutinize the genuineness of the signature. That is in paragraph 32 of the on the withdrawal form with the specimen signature. So if it was your duty to verify and a withdrawal slip came and you cleared it means you said, by clearing means you were satisfied that it was the signature of PW1. But PW1 says, no, I have not put this signature, this is not my signature, and I have never withdrawn it. But postal, in the passbook, of course, it has not been seized. But in the postal documents, there has been withdrawal of rupees 8,500. And admittedly, at that point of time, both of you were in charge. Your two persons' role has been defined in the charge sheet, what you are doing. One is the postal assistant, the other is, though he was a postal assistant, but he was the head clerk during that relevant period. Okay, you complete this evidence. Complete this PW8.
May I plus from para 20?
You are reading paragraph
32.
30, yes. 32 or 33. 32 you have completed, yes.
I have noted in my para 33. I have noted in my report that my predecessor S.K.SAHOO and Inspector Jaspur Road Sub Post Office. I have also noted in my report that my predecessor S.K.SAHOO had not reported anything adverse against H.N. Sethi, and A.N. Panda. Exhibit 53 has not been submitted by me but submitted by S.K.SAHOO, the then Superintendent of Post Office, Cuttack North Division. The report which I submitted after conducting inquiry is not available in the case record.
Just go slow. The report which I submitted after conducting the inquiry is not available in the case record. Okay. Then 53 is that report which is submitted. Okay. That was not submitted by him, but it was submitted by A.N. Sahu. A.N. Sahu has not been examined.
And K.C. Hota also conducted this.
No, K.C. Hota did not find anything. That is, but the এই ଯୋଉଟା ପ୍ରଥମରେ କହିଲାନି paragraph number 32 ରେ जो it was the duty of the accused Ken Panda तादेर कहला जे my report 50 exhibit 53 से सेया कही दला but एठी again कहूची जे 53 is not submitted by me but it was submitted by A.N. Sahu and my report is not available in the case diary. So exhibit 53 is not the report of PW8. Para 33. It is the report of one A.N. Sahu who was not examined. And PW8's report not available in case record. সেটা মধ্যে হচ্ছে paragraph 33 রে. All right, but he says that I have submitted. Continue.
The report which I submitted after conducting inquiry is not available in the case record. I have submitted my report to the Superintendent of Post Office North Division Cuttack and basing on my report, the then Superintendent Post Office North Division Cuttack submitted a report to PMG Bhubaneswar Bhait Exhibit 53. It is not a fact that I have not conducted any inquiry and submitted any report. It is not a fact that I have not reflected in my inquiry report that the accused person did not commit any fraud regarding withdrawal of money from the passbook of account holder. It is not a fact that due to pressure of work accusation, Sethi could not verify the genuineness of the signature of the depositors in the withdrawal form with their specimen signatures, and that I advise him to deposit the said amount for that purpose. It is not a fact that Exhibit 54 was prepared as per my dictation and instructions. It is not a fact that no witnesses have signed in Exhibit 54 and I have manipulated the signature of the witnesses therein. It is not a fact that the accused persons are no way involved in this case.
Okay, this is so far as account of PW1 is concerned. So what about PW2? His account, his name is Janaki Vallabha Pradhan and the amount is rupees 6,000.
Yes. I may place that
Please,
evidence.
first PW2's evidence you place.
Yes, ma'am. I am Janaki Vallabha Pradhan, PW2. I have got a RD account in Jaspur Road Railway Station Post Office bearing number so and so. By the time of opening, the said account was specimen signature was obtained. The specimen signature card is marked as Exhibit 7 and my signature is marked as Exhibit 7/1. On 3/7/93, I never withdrawn rupees 6,000 from my account, RD account. The signature marked as Y and Y/1 for identification in the withdrawal slip dated 3/7/93 are not my signature. The withdrawal slip is marked as Exhibit 8. Some postal officials during course of inquiry recorded my statement on 16/1/94. The statement in the 2 sheet is marked as Exhibit 9 and 9/1 is my signature. On the same day, the postal authority obtained my specimen signature in a sheet which is marked as Exhibit 10. My passbook in respect of the above RD account always remain with Murali Babu, our office cashier. I did not complain against the two accused persons before any authority. I have received the matured amount after 8 months of the matured date. Besides examination by the postal authorities and recording my statement, the CBI inspector had examined me, but I do not remember the date, but it may be in the year 92. It is not a fact that mark Y and Y are my signature.
आर पासबुक टा कोन राखुन
RD.
आरडी अकाउंट अच्छा
आगे.
फास्ट खाली सेविंग अकाउंट थला बाकी समस्त आरडी अकाउंट PW1 रो खाली सेविंग अकाउंट बाकी सब
PW1 रो सेविंग बैंक अकाउंट
ठीक है
अच्छा एमान समस्त आरडी अकाउंट
से निजे कहूची तारो अकाउंट थाए तारो.
हम्म
He has admitted that RD account always remain with the Murali Babu, our office cashier.
मुरली बाबू एग्जामिन ही ना हेजंदी कितना नंबर सही
PW7.
wait my account always remain with Murali Babu, office cashier. Murali Babu
Muralidhar Satapathy.
examined as PW7.
आगे.
PW7. Okay, what this witness has stated, PW2, Shekhalla, I have got on RD account, all right. My signature, specimen signatures were taken and he proved his signatures. Then he denies that on 3/7/93, he never withdrew the amount, 6,000. Okay. And he denies that Y and Y1 are not his signature. Withdrawal slip house relevant withdrawal slip is exhibit 8. Okay. Now come to the evidence of PW7, you said.
And that withdrawal slip रे तारो signature टा exhibit है नहीं.
Kahara?
That is the withdrawal slip is marked as exhibit 8. Some postal officials during course of 7 and 7/1 are specimen signature, and 8 is the withdrawal form, withdrawal slip. And some postal official during the course of inquiry recorded my statement on 6/1/94. The statement in 2 sheet is marked as exhibit 9 and 9/1. That is statement given to the postal official, and the signature is 9/1. Is on the same day the postal authority obtained my specimen signature in the sheet which is marked as
कोटा मार्क ही नहीं बिले अपन को
मु कहछि जोटा withdrawal slip 8 हला withdrawal slip रे ता signature थिबा कथा
तार सिग्नेचर पर से कहूची तादर जो सिग्नेचर अछि सेटा को तार नुहे बेली सेटा मार्क ला Y and Y/1
Y and Y1 are the signature.
सेही विड्रॉल स्लिप टा होची डेटेड होची 3/7/93
आगे
सी जदी कहि थांदा एटा मो सिग्नेचर बेली मार्क हेई थांदा 8/1 बा 8/2 से तो मना करछि ना एटा मो सिग्नेचर नुहे. Yes, next.
And in cross is stated that I did not complain against the two accused persons.
That's all right. Now we come to that evidence of PW7.
PW7 Muralidhar Satpathy.
Yes.
In the year 1993-94, I worked at UDC in Jaspur Road Electric Division. At that time, Ramakant Sahu, Gangadhar Nayak and Janaki Valla Pradhan were also working with me in my office. The said 3 persons had RD accounts in Jaspur Road Post Office. As per the practice adopted for RD accounts, the amount was being deducted from the salary and was accounted to the concerned post office along with amount and passbook account numbers. About 120 to 150 persons were having account number in the said post office. After receiving the amount, the post office used to grant stamps receipt During the year 93-94, Shetty Babu, identified in the court, was the dealing assistant in the Jaspur Road Post Office. In the year 93-94. One Sri S.K.SAHOO, an account holder of the post office and co-employee of our office, approached me for issuing a memo, and as his amount had matured, I sent a memo to the Shetty Babu along with passbook stating that the amount had matured. Exhibit 14 is the shared memo slip already marked, and that memo was written by me in my own hand. I do not know what happened thereafter. I also inquired from Sri Sethi Babu the passbooks of Ramakanta Sahu, Gangadhar Naik, and Janaki Vallabh Pradhan, and Sri Sethi replied me that the books were seized by the inspector and hence he could not return them. I have examined by the CBI inspector in this case. All these for all the employees of our office did not have account in Jaspur Road Post Office. I cannot name all 120 depositors. After deposits on the passbook in the post office, after the up-to-date entries, the passbooks are written and
you said that that Murali whom PW2 was referring to is PW7.
again.
But PW7 has not stated anything in respect of this Janaki Vallabh. But where he has stated about Janaki Vallabh?
It is
I have
at the time of in the year 90, I worked as UDC in Jaspur Road elected division. At that time, Ramakanta Sahu, Gangadhar Naik, and Janaki Vallabh Pradhan were also working with me in my office.
Just a minute. Yes, okay. Over here it is there. Okay. Working with my office. All right. Said 3 persons had the account. That means this all the electrical. They said 3 persons had RD account in Jaspur Road Post Office as per the practice adopted for the ED accounts. The amount was being deducted from the salary and was accounted to the concerned post office along with the amount and the passbook account number. About sponsor persons are having RD account ro withdrawal procedure କିଏ କହିଛି? ସେଟା କୋଉ ଟାଇପ ର ହବ କେମିତି? ଯେମିତି ସେ ଆର ଆକାଉଣ୍ଟ ର ସେ ଡିଟେଲ କହିଦେଲା, ସେ ୱିଟନେସ୍ କହିଛି କି PW8 ହଁ paragraph 4 ଟା ଆଉ ଟିକେ ପଢିଲେ PW8 ର
For codified in the postal manual, the procedure for withdrawal from SB and RD accounts in
same ଲାଗୁଛି ହଁ ଦେଖିଲେ ହଁ ପଢନ୍ତୁ
is that the depositor should submit the application form for withdrawal along with the passbook at post office counter. The concerned saving bank postal assistant should scrutinize the application form, examine the specimen signature of the depositors in the application form, and compare the same with the signature in the specimen signature book, and on satisfactory certification of the specimen signature, he will allow the withdrawal. In fact, he should make necessary entries in the application for withdrawal and also make a necessary entry in the concerned SB or RD passbook, authenticate the entry by putting his initial and date stamp or concerned office and return the passbook to the depositors which require to amount of withdrawal. Thereafter, he will prepare a list of transactions made by him during the entire
ତାହେଲେ ଆରଡି ମନେ କରନ୍ତୁ ସେ ଇଏ ଯାହା କହୁଛି ପାରାଗ୍ରାଫ ନମ୍ବର 4 ରେ ଯଦି ଏସବି କୁ ଛାଡି ଦିଅନ୍ତୁ ଯଦି ଆରଡି ଆକାଉଣ୍ଟ ଜଣଙ୍କର ଅଛି then how he will come and withdraw the amount that procedure has been stated so ଦିଟା ଯାକ କେସ୍ ରେ ଦରକାର ହଉଛି ଯେ ପାସବୁକ୍ କୁ ସବମିଟ କରିବା that is the first requirement କୋଉଠି ସବମିଟ କରିବ ନା ପୋଷ୍ଟ ଅଫିସ କାଉଣ୍ଟରରେ पोस्ट ऑफिस काउंटर रे सबमिट करिवो एवं सबमिट कला परे पोस्टल असिस्टेंट अर्थात से जो काउंटर जे बसी थिवो सीए स्क्रूटिनाइज करिवो एप्लिकेशन फॉर्म माने विड्रॉल फॉर्म जोटा examine the specimen signature of the depositor in the application form and compare the same with the signature in the specimen signature book and on satisfactory certification by the you will allow withdrawal. Okay. In fact, he should take necessary entry in the application for withdrawal and also make necessary entry in the concerned SB and RD passbook. Authenticate the entry and by putting his initial and the date of the stamp and consent. In this RD accounts रो documents कौन सी चीज तार जो PW2 रो पहला RD account तार number दे दिला 11,663 by the time of opening of the son's signature वाला
the paragraph 2 रे से कहछि जो PW7 कहले I do not know what happened thereafter. I also inquire from Sri Sethi about the passbook of Ramakant Sahu, Gangadhar Naik and Janaki Vallabh Pradhan, and Sri Sethi reply me that the books were seized by the inspector.
ସେ କଥା ତ କିଛି ଇନ୍ସପେକ୍ଟର କହୁନି
ନା, he should not
ସେଗୁଡା ସେଇ ଯୋଉ ପାସବୁକ୍ ଗୁଡାକ ଜବତ ହେଇଛି କି ଏଇ ଯୋଉ ଏମାନଙ୍କର 2, 3 ଆଉ 4 ର 1 ର ତ ଜବତ ହେଇନି 2, 3, 4 କିଛି ମିଷ୍ଟର ନାୟକ
Yes, your lordships.
ଏଇ ଯୋଉ 1 ର ତ ଜବତ ହେଇନି ପଚାରୁଥିଲି ପାସବୁକ୍ ଆପଣ କହିଲେ ହେଇଯାଉ ଏଇ ଯୋଉ 2, 3, 4 ର PW3 ମଧ୍ୟ ସେମ୍ ଏଭିଡେନ୍ସ ଦଉଛି ଯେ ସେ ଯେତେବେଳେ ପଚାରିଲା ଇନ୍ paragraph number 2, read paragraph number 2 of PW3.
My lord. On 26/6/93, I withdraw a sum of rupees 2,500 from the said account. After the maturity of the deposit, the cashier authorized me to get the passbook from the postal department. This is the authorization of the cashier marked as Exhibit 14. The postmaster, after seeing Exhibit 14, told me that passbook was submitted to the head post office and it would be returned after it was received back. This is the withdrawal form submitted by me on 26/6/93 while withdrawing the amount marked as Exhibit 15, and these are my signature thereon, Exhibit 50/1 and 15/1 and 15/2. I was examined by the IO. It is not a fact that I stated before the IO that somebody has withdrawn from my account of rupees 2,500 on 26/6/93, forging my signature. It is true, Assistant Superintendent of
No,
Postal.
this man did not support the prosecution case for which he was declared hostile. ସେ ମନା କରୁଛି, it's not a fact that I have stated before the IO. So 2,000 ଟଙ୍କା ମୋ ଫର୍ଜିଂ ସିଗ୍ନେଚର ଏଗୁଡାକ ସେ ମନା କରୁଛି। So
ସେ ନିଜେ ସବମିଟ କରିଛି ବୋଲି ବି କହୁଛି।
that he has told, ସେଇଥିପାଇଁ ତ ହୋଷ୍ଟାଇଲ ହେଲା ସେ ତାକୁ। prosecution case ହଉଛି ସିଏ ନିଜେ ସବମିଟ କରିନି, ଏଇଟାକୁ ଆକ୍ୟୁଜ୍ଡ ମାନେ କରେଇଛନ୍ତି ତାର ସିଗ୍ନେଚର ଫୋର୍ସ କରିକିନି। କିନ୍ତୁ paragraph 2 ରେ ସେ କଣ କହିଲା ଯେ on 26/6/2023 I withdrew rupees 2,500 from the said account. The maturity of the deposit of the cashier authorized me to get the passbook from the postal department. This is the authorization of the cashiers from the so-and-so. After seeing so-and-so, it would be returned to him. But withdrawal କଥାଟା ସେ ନିଜେ ମାନୁଛି, ସେଇଥିପାଇଁ ତାକୁ ହୋଷ୍ଟାଇଲ ଡିକ୍ଲେୟାର କରାଗଲା ଯେ ଯାଇ ତମେ ପୋଲିସ ପାଖରେ କହିଥିଲ ଯେ ତମର ଆକାଉଣ୍ଟରେ କିଏ ସିଗ୍ନେଚର ଫର୍ଜରୀ କରିକିନି 2,500 ଟଙ୍କା withdraw କରିନେଇଛି। So that is how the prosecution has PW3 has not supported prosecution case, rather stated that he himself withdrew rupees 2,500. He was declared hostile. Okay, let us go to PW4.
I was having RD account in the Jaspur Road Post Office. I was working as lineman at Jaspur, and my cashier used to deduct 200 per month from my salary and deposit the same in the aforesaid account on my behalf. This is my application for opening the account marked as Exhibit 19. These are my signature thereon marked as Exhibit 19/1. This is the specimen signature slip I have given to the postal authority at the time of my opening the account marked as Exhibit 20, and this is my signature thereon marked as Exhibit 20/1. On 14/6/93, I have not withdrawn rupees 500 from the said account.
5,000.
5,000 from my 5,000 from my said account. This is not the withdrawal slip submitted by me, marked as X by 1 confronted. Those are not my signature. They are on X by 2 and X by 3. I have lost 5,000 from the above account, for which there was an inquiry by the Assistant Superintendent of Post Office. This is my statement given by me to him, marked as Exhibit 21. This is my signature in my statement marked as Exhibit 21 by 1. Those are my specimen signature given to him as Exhibit 22. Para 2. The deposit in my accounts are used to be made through my office only. I never withdraw any amount from the said account before the maturity of the deposit. After the maturity of the deposit, I went to the post office for withdraw the amount. At that time, I saw the accused for the first time. It is not a fact that I used to withdraw the amount through my agents also. It is not a fact that my answers in the Exhibit 21 are false. I have withdrawn the amount against my aforesaid account, which I was entitled to. Initially, I have lost 5,000. Thereafter, it was compensated. He also stated that he personally withdrew. In paragraph 2.
Paragraph?
Paragraph 2, the deposits in my accounts are used to be made through my office only. I never withdraw any amount from the said account before the maturity of the deposit. After the maturity of the deposit, I went to the post office for withdraw the amount. At that time, I saw the accused for the first time. It is not a fact that I used to withdraw the amount through my agents also. It is not a fact that my answers in Exhibit 21 are false. I have withdrawn the amount against my aforesaid account, which
I have withdrawn.
Para 2, remember. Last line, last sentence. It is not a fact that my answer in Exhibit 21 are false, comma, I have withdrawn the amount against my aforesaid account.
This line is supporting you. PW4. Okay. So, what is your submission? Have you prepared any note of submission, small note or anything like that to summarize what is your actually, because it's a revision petition and two courts of concurrent facts. They have one court has already held you guilty. The other court has in the appeal, your appeal has been dismissed, right?
Yes.
So the scope of revisional jurisdiction is very restricted in that sense. So yes, so we have gone through the evidence on record in entirety because it's a case of that nature. Unless evidence is not gone, then it cannot be properly appreciated. We have gone through it. So unless you make out some clinching point, because reappreciation of evidence within the scope of revisional jurisdiction is not permissible unless some material evidence has been left out or inadmissible evidence has been taken into account. Those things, unless you brought out those things on record, it is not possible to deal the matter as if I am a trial court or an appellate court. So the scope being limited, what is your submission? How do you say that the conviction of your client, which has been upheld by the honorable by the land and appellate court, was not proper or justified?
But the forgery which has been
Use the mic properly.
the forgery which has been imposed, I have not forged their signatures. I have not forged the petitioner.
Nobody has seen what has happened. Nobody has seen that who has done it or who has done the forgery. Question is that suppose the vital documents of the postal department are available with you. Unless you pass, that amount cannot be withdrawn from the account of any of these depositors. Maybe 1, 2, 3, 4, it cannot be withdrawn. So for that, a proper procedure is there. Withdrawal slip has to be filled it up. Then how it is to go and who is to verify, and ultimately, if it will be passed, then only somebody will get the money. So postal documents indicates that from the accounts of 4 persons, this amount has been withdrawn. Those out of those persons, at least 2 of them are coming and saying that they have not withdrawn. It's all right that PW 3 and 4, they have stated that yes, they have withdrawn the amount. That's a different matter. But again, 1 and 2, they have stated that we have not withdrawn. Now, how do you say that and the withdrawal slips, that is one of the most important documents in this case, those bears your signatures, and that means which has been proved by the handwriting expert at that point of time. That's why I was asking why handwriting expert, if it has been collected, then why it was not
and it has also been proved, and
yes.
it has also been proved by PW 8.
Right.
PW 8 is also saying that I'm acquainted with their handwriting and it is their handwriting.
Apart from that, the handwriting expert opinion also, of course, the IO has not done it, but it has been done because when the inquiry was going on, postal departments at the instance of that has been proved by PW 8.
The IO said in paragraph 20, your lordships, that it will be a duplication of exercise because they have done it.
Right. Obviously, it should not have been done for the second time. So, how do you overcome this evidence?
This verification of the signature is the duty of the head clerk. Verification of the signatures tally to the original documents, original passbook is the duty of the head clerk, madam.
Okay.
So I is evident from the charge sheet and from the PW8's madam.
Suppose that man, let us say PW1, he says he has handed over the passbook to you.
Yes.
We'll come to that part. He has handed over the passbook to you. You said him that you come afterwards, and after it is up to date, you will get the money. It will be operational. Then one can, or in other words, on that particular day, he was not allowed to withdraw the amount from his own passbook, from his own postal account, on the ground that it has not been made up to date. So accordingly, he deposited the passbook with you, and the proof is that receipt. And in that receipt, the amount has also been mentioned, that what is the amount.
Hello.
Now, so that man, thereafter, there is no scope for him. If the passbook remains with you, and if the person doesn't come to the bank or doesn't send anybody with all those necessary documents, it is not possible on his part to withdraw the amount. But the postal document indicates that on a particular day, maybe after 4 months, because that passbook was deposited in June, in October, it is mentioned that 8,500 has been withdrawn. That is, admittedly, that amount has been withdrawn. Question is that if that man has withdrawn, then obviously you are not liable. But if that man has not withdrawn, and the documents of withdrawal bears your signature, how you will escape? Particularly when two courts of concurrent jurisdiction, that means trial court and appellate court, have assessed the evidence, and the scope of revisional jurisdiction is, you are right that your role is to receive it. Suppose withdrawal memo is there, you are to give it to that that postmaster or whatever it may be, head clerk, and he is to verify the because that will be available with him to verify. And if he says pass, you can only pass it and give the money to the person concerned. But all these things have not been done in that case. That means the man had not come. That PW1 says I have not come. That other person was not examined. So you retain the passbook. What?
The petitioner send the passbook to the head
Of
post
course,
office.
that I was pointing out. They should have done certain things.
Yes.
That exercise has not been done. But you cannot deny that you have not kept the passbook, because the exhibit 1 is that document which shows that passbook was handed over to you, or PW1. So, and passbook was also not seized. They should have brought all those evidence. It's one night. That's one of part. Lacuna is there. Of course.
But the lacuna is not that material to discredit the prosecution case as a whole, your lordships. They should have done it, completely admitted, your lordships. But after concurrent finding on facts by both the courts, in a revisionary jurisdiction, just because the passbook was not seized, your lordships, is not that material which will completely discredit the prosecution's case. particularly when your lordships, the other evidence is available on record, both documentary and.
All right, Mr. Sarangi, what do you say? What is your submission?
I am a petitioner.
Yes, you are the man.
My lord.
According to the prosecution, your role is to verify the signature which is appearing in the withdrawal slip with reference to the specimen signature which is available in the post office.
My lord.
And say that yes, you are to certify, because the person who is receiving the passbook in the counter, he is having not the specimen signature with him. You are the postmaster or the head clerk who is in charge of those specimen signatures.
No, my lord. ମୋ ପାଖରେ ସେମିତି କିଛି record ନଥାଏ. My lord,
the evidence has come like that, Mr. Sarangi. The evidence is that.
My respectful submission to my lord. Admittedly, I am a head clerk cum supervisors. ମୋ under रे 15 जन daily clerk अछंती. Daily 1500 file put हुए ମୋ पाखरे. I am my duty only to pass. But a sanction authority.
You see the what has been mentioned. I am again. Have you got the charge sheet with you? That is also the evidence.
But my lord,
A.N. Panda being the
postal sanction mo against nahi 197 nahi.
A.N. Panda being the postal assistant was looking after the work of head clerk from July 92 to May 94, during which period this thing has happened. His duty was to verify the specimen signatures of the depositor in case of withdrawal up and above 500. 500 ଟଙ୍କାରୁ ଯଦି ଊର୍ଦ୍ଧ୍ୱ କୌଣସି withdrawal ଆସିଲା, ସେ କେସରେ ଆପଣଙ୍କର ଦାୟିତ୍ୱ ହେଉଛି ସେ withdrawal slip ର signature ଆଉ specimen signature କୁ verify କରିକିନି ଆପଣ ହିଁ certificate ଦେବେ, ଆପଣ ହିଁ ପାସ୍ କରିବେ, ତାପରେ ଯାଇକିନି ଟଙ୍କା ତାକୁ ମିଳିବ।
ମୁଁ sanction କଲା ପରେ postmaster ପାଖକୁ ଯିବ for sanction।
ହଁ,
head clerk pass କଲା ପରେ ସେଟା postmaster ପାଖକୁ ଯାଏ।
अरे you are working as head clerk and
postal my respectful submission to my lord, postal circular ଅଛି ଯେ head clerk ଏତେ ଫାଇଲ practically ଦେଖି ପାରିବନି, ଯୋଉଟା complain ହବ ସେଇଟା ସେ କେବଳ ସୁବିଧା କରିବେ। daily 1500 କେସ୍ ମୋ ପାଖକୁ ଆସିବ, it is practically verify 11 ରୁ ଗୋଟାଏ ଭିତରେ। So I have no role in this case। এই କେସରେ I have no role। So in this regard, departmental sanction ନାହିଁ ମୋ against 197 service। I am not suspended, I am not so cause। ମୋର formal duty। clerk ଗୋଟେ ତା ଅଣ୍ଡରରେ 12 ଜଣ କ୍ଲର୍କ ଅଛନ୍ତି, 1200 ଫାଇଲ ଆସିବ ମୋ ପାଖକୁ। ଇଟ୍ ଇଜ ପସିବଲ? ଫାଇଲ ବାହାର କରି କମ୍ପ୍ୟୁଟର ସିଷ୍ଟମ ନାହିଁ, ଫାଇଲ ଗୋଟେ ବାହାର କରି କଲା ବେଳକୁ ଗୋଟେ ଦିନ ଲାଗିବ। ତ ଯାହା ଡିଲିଂ ଏଷ୍ଟାଣ୍ଡ ଦେବେ ମୁଁ ତାକୁ ଗୁଡ ଫେଥରେ ସାଇନ୍ କରିବି। ଇନ୍ ଦିସ୍ ରିଗାର୍ଡ ଆଫେୟାର୍ସ କୋର୍ଟ ଡିସିଜନ ଅଛି, ତ ୱିଦାଉଟ୍ ମାଇ ନଲେଜ ହେଡ୍ କ୍ଲର୍କ ସୁପରଭିଜନ ଅଥରିଟି କରିବେ। ଯେ ପୋଷ୍ଟ ଅଫିସ ଇଜ ଭେରି ବିଗ ପୋଷ୍ଟ ଅଫିସ, ଯାଜପୁର ରୋଡ ପୋଷ୍ଟ ଅଫିସ। 15 ଜଣ ଡିଲିଂ ଏଷ୍ଟାଣ୍ଡ ଅଛନ୍ତି, 15 ଜଣ ଡିଲିଂ ଏଷ୍ଟାଣ୍ଡଙ୍କର ହାରାହାରି 1000 ଫାଇଲ ପାସ୍ ହବ through head clerks, but it is practically not possible to 1000ଟା ଫାଇଲ ମୁଁ ବାହାର କରି ସାଇନ୍ କରିବି। In this regard, ମୁଁ ଫାଇଲ law postal circulars ଯେ ସୁପରଭିଜନ ଅଥରିଟିଙ୍କର practically ନାହିଁ ପାୱାର ଯେ ଏତେ ଫାଇଲ କଲଫର କରି ଭେରିଫାଇ କରିବେ। So I have no intention, no role.
That general submission would not do. When the witnesses have stated what is the role of yours in the during their examination, you should, if there is any circular, you should confront to them that look, what you are saying is against this circular. Circular says that my role is this. Unless you confront it, prove that at the revision stage you cannot raise those things. The witnesses have been examined. The material
197 more sanction.
Is it necessary for such type of offenses that sanction is to be? Is it necessary when you are committing forgery?
Commission of a crime may not be a part of his official duty, your lordships. There has to be a direct nexus.
Forgery is
official duty.
Commission of forgery and using that forged document to be genuine is not a part of his official duty.
forgery, there are number of decision on this point. You can file your decision. There is no problem. If you say that sanction is necessary, file your decision. If you say that in a case of forgery, you are a head clerk, this accusation is forged document, creation of forged document, and using the forged document as genuine, and you say that sanction is necessary in such offense, file your citation.
Whether that issue can be raised, your lordship, when appeal is dismissed in revision stage. They never raised it, your lordships, neither in the trial court nor in the appellate court. For the first time, they are raising it here.
So I'm closing the case. You may file your written note of submission or any citations. Mr. Nayak,
I want to file some judgments, your lordships.
He is raising one point. You also give those decisions on this sanction part. In the case of this forged document, there are number of decisions. So give those decisions. So when you will file these your written note and citations?
Probably what written notes is with
You have already filed?
probably is there. In my file it is there or the file.
Regular Ashiki written note.
I will file a better note. Within
That would be better.
yes.
Yes. So Mr. Sadangi,
My lord,
whatever decision or note, if you anything you want to file, you just file it. I'm closing it today. File it. Don't make it late. Maximum file it by Monday or.
So the copy should be given to me.
Right.
I'll file it after 2 days after I receive it, your lordships.
If you give it to Mr. Nayak by 31st, then he will file his by 4th of August.
My respectful submission to my lord, now the age of the petitioner, my lord, about to 90. Most of the contact रे आसुना, जे alive or dead, that is also doubtful. My respectful submission, 10 days time minimum necessary, my lord.
No. 10 days. You have argued. You have to prepare your note. The other thing is to be that is your arrangement. But so far as submission of note is concerned, written note of submission and citation, that you do it unnecessarily, because this type of matters, once I hear it and time runs on and you don't file anything, it would be a futile exercise.
By 3 August, my lord.
I am writing in my order that you both of you made submission that you will file the written note of argument by 31st, giving copy to Mr. Nayak, and whatever written note Mr. Nayak is to file or any citation, that is to be filed by 4th. With that, I am closing the argument. Rest is up to you. Whether you file or not file, lekhijan. Hard this is Madhumita Panda, Land Council, appearing for petitioner Rudanand Sethi in CRL REV number 21 of 2003, and Mr. E.C. Sarangi in CRL REV number 17 of 2003. So also Mr. Sarthak Naik, Learning Special Public Prosecutor for CBI. The Learning Council for the petitioner submit that they will file their respective written note of submission with citations by Monday, by date by 31st of July 2023, giving copy to Mr. Sarthak Naik, and who submits that on receipt of the same, he will file his written note of argument / citations by 4th of August 2023. Hearing is closed. Judgment is reserved. Yes, anybody else is there? Please come. Which is item you?
I'm in item number 2, minus.
2. Okay. What is the offense, Mr.?
Minus is under minus 7A of the Essential Commodity Acts, violating the Sugar Control Order, minus. Sugar Dealers License Order 1963.
Who is to do this matter?
I am present, minus.
No,
Just
it is
tell the
minus
killing.
110.
No, I just want to what is the offense and what is the
offense is under sugar minus
no, what is the judgment or operating part of it?
judgment minors.
Offense under Section 7 of the EC Act.
Under Section 7 of the EC Act.
Which is the impugned order?
Impugned order minors, it paper book is there, minors. Paper book impugned order at page 7 to 14.
এটা ଏସେନ୍ସିଆଲ କମୋଡିଟିଜ ଆକ୍ଟରେ ଯୋଉ ତା ଦେହରେ ଥିବ ଓଡିଶା ସୁଗର ଡିଲର୍ସ ଲାଇସେନ୍ସିଂ ଅର୍ଡର ପେପର ବୁକ୍ ଦେଖିକି ତା ଅର୍ଡର ଗୁଡାକ ବାହାର କରିଦିଅ ସେଇ ଅର୍ଡର ସେଇଟା
1963
63 ହଁ 63 ସେ ଅର୍ଡରଟା ବାହାର କର ଆଉ କଣ ରେଲେଭେଣ୍ଟ ସବୁ
ସେଇ ଗୋଟା ଅନ୍ୟ ଯାହା ମୁଁ ରେଫରେନ୍ସ କରିଛି because it was a hard manners by Justice D. Satpathy, and I've given those documents, the citations and all these things are there in the record.
Okay.
Now the man is above 80. Manners confined in manners.
No, it's
punishment is 6 months.
250 also. Or it will take up after lunch. I was just going through that.
Item 2.
That's the
Please read the impugned order.
Yes, impugned order, at page 7 to 14.
Yes.
Could I read in detail, minutes?
Yes, yes.
Clause C is important, the clause A, serial GR case number 72 of 1986. The report, the report was submitted on 2/12/1986. Then, finding part H. Both the accused, Sri Om Prakash Agrawal, the proprietor, and Messrs. Shankar Misri Factory, Malgodam, Cuttack, and Lakshmindhar Pradhan, branch manager, Odisha Consumer Cooperative Federation Limited, Malgodam branch, Cuttack, stands prosecuted under Section 7 of the Essential Commodity Act for having contravened the provisions of the Odisha Sugar Dealers Licensing Order 1963. The prosecution case in short is that S.C. Das, Inspector Vigilance City, Cuttack, lodged a written report to the SP Vigilance, Cuttack Division, Cuttack, on 2/12/1986, stating that he collected a reliable information regarding the clandestine business in sugar by accused number 1, Mr. Shankar Misri Factory. Therefore, he, along with Inspector T.B. Tripathi, proceeded to the spot, tested out the accused number 1. During inspection, the informant came to know that the accused number 1, Om Prakash Agrawal, is owning a Misri factory in Meria Bazaar, who lifted 200 packages of the imported sugar, Philippines, from Odisha Consumer Cooperative Federation, Malgodam branch, Cuttack, on 22/1/11/1986, under the receipt number 13183 dated 21/11/1986, for rupees 52,000. Each packet weighs 50 kgs. Those 100 quintals of sugar were stored in Messrs. Santalia Brothers, who is owned by the brother of the accused number 1. He also denied to have possessed any sugar license for dealing with such purchase and storage. On further verification to the accused number 2 shop, the informant came to know that it too did not possess a valid license for carrying on business in sugar. Therefore, he has lodged the FIR against both the accused for having contravened the provision of Sugar Licensing Order 1963, punishable under Section 7 of the Essential Commodities Act.
Who is this appellant number 2? The accused number 2?
Then Miles knows that the consumer society, they were purchasing that the sugars are exported, and they were selling it.
Accused number 2 is
branch manager.
Branch manager,
Orissa Consumers Cooperative Federation.
Okay, Lakshmindhar Pradhan, right?
Yes.
Okay, all right. Continue. Yeah.
The plea of accused number 1 is that he owns a mystery factory for which there appears to have no necessary for any license. Without any license, one can possess 100 quintal of sugar if he is a bulk consumer. The plea of the accused number 2 is that he had a license for dealing with sugar, but the prosecution has unnecessarily implicated him in this case. In order to further its case, the prosecution has examined 4 witnesses, and defendants has declined to examine any witnesses. P.1, who is nephew of the accused number 1, deposed in the evidence that he stored 100 quintals of the sugar on 22/11/1986, which contained into 200 packages, and those were imported sugar from Philippines. He further proved the seizure and claimed to have kept those sugar under his zimma at Exhibit 1. In cross-examination, it is brought out that the sugar purchased by accused number 1 was stored for purpose of preparing of sugar candy, and he owned a factory in Meria Bazar, Cuttack. PW2, Banabasi Tripathi, who was the Inspector Vigilance on 22/11/1986, deposed to have accompanied PW3, S.C. Das, found the accused number 1 in possession of 200 packets of imported Philippine sugar. Each packet contains 50 kgs. It revealed during investigation that the accused number 1 stored those sugar in the Malgodam of Santalia Brother, Cuttack. The sugar was stored by the accused number 1. Admittedly, accused number 1 did not possess a license to deal with the sugar. He proved the seizure list Exhibit 1. those sugar had been purchased from Odisha Consumer Cooperative Federation, and accused number 2 was its manager. PW3, Inspector of Vigilance, Sri Sarat Chandra Das, deposed during evidence that on 22/11/1986, after reliably collecting information that the accused number 1 has been dealing with sugar processed with his company PW2 to Messr Shankar Mistri factory owned by accused number 1. The proprietor, namely accused number 1, found to have purchased 200 packets of sugar stored in another Godam belonging to Santalia Brothers, which was a sister association of the accused number 1. Those 200 packets were purchased from accused number 2 and stored in the Malgodam. After seizure of the sugar, it was kept under Jima of PW1. He proved the seizure list. After preliminary inquiry, he drew up the FIR by Exhibit 3 on the direction of SP Vigilance. The Inspector, Sri M.N. Dolai, of the investigation. PW4, the investigating officer in this case, supported the version of the prosecution and deposed that the accused number 1 did not possess any license for dealing with the sugar. In the short question now arises whether the accused number 2, who allegedly sold the sugar to accused number 1, has possessed any license for the sale of such sugar. In this connection, the evidence of PW2 and 4, although disclosed that the accused number 2 did not possess any license, but the defense has summoned the original licensee from the supply office, which is marked as Exhibit A. From Exhibit A, it is made crystal clear that Odisha Consumers Cooperative Federation, Orissa, is declared as a licensee since 1989-90. So, therefore, the prosecution story that accused number 2 did not possess any valid license for dealing with sugar completely falls to the ground. Accordingly, I hold that the prosecution number 2 not able to make out any case against accused number 2, Lakshmendra Pradhan. Let me now find out how far prosecution has been able to prove the case against accused number 1. Accused number 1 claims to be the manufacturer of sugar candy. The learned counsel for the accused, Sri Mishra, vehemently argued that for preparing sugar candy, one does not require to possess any license. He further contended that since the accused number 1 is a bulk consumer, there is no necessity of having license from the state government. In this case, the bulk consumer has been defined as follows. Bulk consumer means jalis, hospital, sanctuaria, convalescent homes, nursing homes, orphanage, workhouses, asylums, infirmaries, hotels, school, college, university, bakeries, confectionaries, hotels, and restaurants. The learned counsel for the accused number 1, Sri Mishra, mentioned that accused number 1 being a confectionery, he does not require to possess any license as he is not dealing with sugar. To appreciate the contents of the counsel, I may quote the subsection 3 of clause 3 of Odisha Sugar Dealers License Order 1963. For the purpose of this clause, any person who stores sugar in any quantity exceeding 10 quintal at any time, one time shall, unless the contrary is proved, be deemed to store the sugar for the purpose of carrying on the business of purchase or sale or storage for sale of sugar. Admittedly, the accused number 1 found to have been in possession of 100 quintals of sugar. If a person found possessing more than 10 quintals, it seems to have violated clause 3 of clause 3 of the Odisha Sugar Dealers License Order 1963. In this connection, assuming accused number 1 to be a bulk consumer, even then he cannot store. Well, that's very important. Well, there I will have more on that particular part. He cannot store more than 10 quintals as per subclause 3 of clause 3 of the Odisha Sugar Dealers License Order. On his own showing, he admitted to have possessed 100 quintals of sugar without any license. Accordingly, I found the accused number 1 guilty to have contravened the provision of Odisha Sugar Dealers License Order 1963, punishable under Section 7 of the EC Act, and convicted him thereon. Then conviction matters 6 months, page 313.
देखिए এটা দিয়ে আসছে যে sugar
So I have my old book. But my lords, I have gone through my lords of that order that is quite up to date, and some amendments are brought in, and that is there in my lords book, but it's not there in my book. I must.
This is amended up to, I think, 89. আমরা এই ঘটনাটা কেবে হয়েছি?
এটা 86
তাহলে এটা 89 ରେ কোন amendment ହେଇଛି ସେଗୁଡା
90 ରେ ବି amendment ହେଇଛି 28 ଆଡ ହେଇଛି ଦେଖନ୍ତୁ restriction of
ନା ଏଇଟା ଯୋଉ ଆସିଲା let us say clause
2390 ରେ ଦେଖନ୍ତୁ 28 ଆଡ ହେଇଛି
inspection was done on 22/11/86
please ଦେଖो amendment
ଏ ଯୋଉ 10 kg ଟା କୋଉ ସେ provision ଥିଲା
ଆଜ୍ଞା
10 kg ଯୋଉଟା not exceeding
3
clause 3
clause 3 licensing of dealers
licensing of dealer ଏଇଟା ଗୋଟେ
ସେଟାରେ amendment ହେଇଛି ଗୋଟେ amendment ହେଇଛି 3 ରେ ଗୋଟେ portion delete ହେଇଯାଇଛି that is omitted in 71 then 2 ରେ a separate license shall be necessary for each place of business achi it is as such then 3 that was amended on 1965 for the purpose of this clause
right who stores sugar in any quantity exceeding 10 quintal সেটা substitute ହେଇଛି 27/9/1979 ରେ substitute ହେଇଛି ମାନେ ଏଇଟା ଘଟଣାଟା ହଉଛି 82 ପରା
86 madam
86 ପର୍ଯ୍ୟନ୍ତ ଆଉ କିଛି ହେଇ ନଥିଲା
ନା ତାପରେ ଏଇଟା 90 ରେ ଆସିଲା 100 quintals
unless contrary is proved
to be deemed to store the sugar for the purpose of
carrying on business
purchase sale and storage of the sale and sugar now my humble contention my lords
so here admittedly it is 100 kg 100 quintal so what is your stand
my humble contention my lords then my lords I will bring it to my lords notice about the definition chapter first the concept of the whole total reading of the order my lords whole total reading of the order reveals two things one is a consumer bulk consumer the second concept is a dealer then a wholesaler and all these things first the concept of bulk consumer means they are being in consumption who are coming within the bulk consumers if I am coming within the bulk consumer then obviously 3 does not apply to me because it is only in respect of dealers no person 3 I am reading 3 minutes no 3:1 no person shall carry on business as a dealer except under and in accordance with the terms and conditions of a license issued in this behalf by this licensing authority. So if I would be having a license and I
come to the definition of dealer.
A dealer means a person engaged in the business of purchase, sale or storage of sale of sugar in quantity exceeding 10 quintal at any time but does not include an industrial undertaking which is engaged in the manufacturing or production of sugar and which is registered or licensed under the Industrial Development and Regulation Act of 1951 and for the purchase, sale and storage of sugar for defense requirement by the army purchase organization of the government of India or by defense authorities.
Even if a person, suppose the prosecution fails to prove that you are engaged in sale activities. But if it is proved that at one point of time you have stored for the purpose of sale of sugar and that exceeds 10 quintal,
then also
it would be deemed that he is a dealer. So now when the storage of 100 quintals has been proved, then you are to prove that for what purpose you have kept
exactly,
it.
Before entering into that
your case is that that is for sugar candy or something.
For preparation of misiri.
ମିଶ୍ରିଟା ତ ସେଇ ବିଜନେସ ପର୍ପସ ନା
ବିଜନେସ ଏଥିରେ ମଧ୍ୟ ଯୋଉମାନେ ଅଛନ୍ତି ସବୁ ବିଜନେସ ହୋଟେଲ ଯିଏ କରିଛି ସେ କଣ ବିଜନେସ କରୁନି କି କରନ୍ତୁ ତା ଦେହରେ ଗୋଟେ ୱାର୍ଡ ଅଛି ଦେଖନ୍ତୁ ହୋଟେଲସ ଅଛି ବେକରିଜ ଅଛି ବେକରି ମଧ୍ୟ ସେଇ ବିଜନେସ ତ କରୁଛନ୍ତି ବଟ୍ କ୍ୱେଶ୍ଚନ ଇଜ ଡାଇରେକ୍ଟ ସୁଗାର ଏବଂ କନଫେକ୍ସନାରୀ ଏ ଦିଟା ହେଲା ଟୁ କନସେପ୍ଟ I brought it for the purpose of preparation of the confectionaries. So I am coming within the definition of bulk consumer. my humble contention that I am coming within the definition of the bulk consumer. May I submit, my lord, in this case, my thing is that the learned trial court held that if in this connection, assuming that accused number 1 to be a bulk consumer, even then, last paragraph, page number 12, even then, he cannot store more than 10 quintals as per subclass 3, clause 3. My humble contention, subclass 3, clause 3 cannot be read in isolation. It must be read harmoniously along with other provisions. My lords, usually, my lords, that is the provision of interpretation. My lords, I need not repeat before my lords. So, thing is that 3 refers to a dealer.
No, that's bulk consumer, dealer. They are two separate
entities.
Obviously, when in a suppose
my humble
example,
contention is that
jail, hostel, that is rightly given those examples. But
now, while I'm coming to that, I am preparing misri, and the misri is a confection. If it is a confectionery, then I am coming within the definition, because my whole total case is that I am a bulk consumer. Because fact, kindly, then I'm taking for a minute, I'm taking just beyond the scope of the particular order. Well, kindly have glass to 2A, the amended provision 2A. 2A says that has been increased bulk consumer. Then they say there, well, kindly see, I don't have that amended provision. 2A.
Bulk consumer means jails, hospital.
That is lordship is reading at
amendment
definition 2. My learned senior is pressing at the amended part 2A.
Please. 2A jota amendment asila to capital A.
Eta diyantu setiro achi.
To capital
kindly see this. I have just taken the printout for your lordship's convenience.
2A. Restriction on
bulk consumer. A bulk consumer shall not store sugar
in excess of 100 quintals. No, that is in excess of 100 quintals in any calendar month.
In calendar month.
Without prior approval of the licensing authority. Here what is the quantity? What is the quantity?
Here in this case, 100
quintals. 100 quintals. So it is not excess of 100 quintals.
Excess of 100 quintals. Now, question is, this
if any bulk consumer stores sugar in excess of 100 quintals without the prior approval of the licensing authority, he shall be liable to pay penalty of rupees
1,000 rupees.
Okay.
So 2A, they brought it in 2A. Kindly let us read it harmoniously, pre and post relationship. So there, prior to this has come intentionally, the legislature brought it in intentionally to limit it within 100 quintals. Before that, there was no such restriction in respect of the bulk consumers.
That came into force in 1990.
But before that, the bulk consumer, the definition of bulk consumer was there, but there was no such restriction. It was either 100 quintal or more or less.
Just.
So, my first humble contention will be
नहीं हो रहा, चलो। Confectionery meaning I was
because it was extensively argued, and in that time also I have given the judgments, and that refers to the definition of confectionery. I have given also that, I think that is there. the judgments, some of the judgments. କେତେ page? ସେଟା ଅଛି ନା confectionery ରେ ଆମର honorable high court, different high courts and honorable supreme court discussed about all these things. Then I will come, my lords, our definition and
this is that
confectionery therefore ଟିକେ ଦିଅ please ଦିଅ ଆଜ୍ଞା ଏଇଟା ମୁଁ ରେଫର କରୁଛି 1963 Madras 460 in other context but definition of confectionery.
Chocolates ମାନେ କହୁଛନ୍ତି ସେଟା confectionery ଭିତରେ
ସବୁ confectionery ଟା
sweets ଟା ବି
ମୁଁ ଏଠି ଆସୁଛି ମିଶ୍ରି ଟା confectionery ହବ କି ନାହିଁ ମୁଁ ସାର୍ ଆସୁଛି ଦେଖେଇବି ମାନେ kindly see para 17
para
17 of the judgment matters. Confectionery therefore is a sweet meat, while the biscuit in its nature bread which has to be
17
okay again ta parku par better definitions are there, very definition with clarity. Confectionery therefore is a sweet meat, while biscuit, but there is a distinction between whether it would be a biscuit or confectionery biscuit will be coming within confectionery or not. That is related to some other issues, but definition I only borrow the concept of definition from that. Confectionery therefore is a sweet meat. But my lord, kindly keep it in mind that. Then my lord, the second edition 1977 Criminal Law Journal 1341 ତା ଦେହରେ ପାରାଗ୍ରାଫ ଟା ଟିକେ ପାରା 2 ସେ ପୋର୍ସନ ଟା ମୋର ଇଏ ଟିକେ ଲିଭି ଯାଇଛି ମାନେ ଇଏ କାଳି ଖସି ଯାଇଛି that they defined the definition of confectionery para 2 ର last portion. Confectionery is defined in Random House Dictionary as confectionery ଟିକେ ଆଜ୍ଞା ଲିଭି ଯାଇଛି ସେଠି ଆସିଲା it is obvious that definition ଟା ଦେଇଛନ୍ତି ତାପରେ ଲେଖିଛନ୍ତି it is obvious that an article of confectionery comes into being only as a result of the process of preparation in which several ingredients are used. This is the confectionery. Then my lords, I am coming to another definition of definition, not another definition, definitions as has been specified by Honorable Supreme Court in reported in 1998-7 SCC 228.
Yes.
There paragraph 6. In paragraph 6, what definition of you dictionary thila?
Yes. Item 6.
While interpreting the word sweetmeat, confectionery means sweetmeat. The first decision says sweetmeat in the entire serial number 8 of the list excludes industrial contention in the notification took into consideration. Then in last portion, in order to find out whether a toffee is a mithai or sweetmeat or a confectionery or a commodity of nature of sweet also ragi and also Webster College Dictionary ନେଇକିରି ସେ ତାଙ୍କର define କରିବାକୁ ଆସିଲେ ଆମର ଦରକାର page 233 the in Consolidated Glossary of Technical Terms Central Hindi Dictionary Ministry of Education Government of India. Let's got it. Confectionery is defined as a mishtarna, mithai in English Hindi Dictionary of Dr. Kamil Balke. The meaning of the word confectionery.
Just a minute, pencil.
Is mishtarna, mithai, sweetmeat has been described to mean as marwa, mishtarna, mithai. Thus, according to the dictionary, mithai is synonymous of sweetmeat in English, and that is why English translation is opposite. That is not necessary, manners. Mithai. Then, manners, I am referring to manners. Our the very old manners will be manners. I will appreciate it. The Purnachandra Bhasakosh. Manners page that I have given that page 6558. It is Misri. ବୈଦେଶିକ ମିଶର ଦେଶ ପ୍ରଥମେ ମିଶ୍ରି ବାସୀଙ୍କ ଠାରୁ ଦେଖି ଭାରତରେ ଏହା ପ୍ରସ୍ତୁତ ହୋଇଥିବାରୁ ନାମ ଶୀତପଳା, ଆମର ସଂସ୍କୃତ ନାମ ଶୀତପଳା, ବଡ ବଡ ଦାନା ରୁଆରେ ପରୀକ୍ଷିତ କନା ଓ ସୁପରିଷ୍କୃତ ଗୁଡ, ସୁଗାର କ୍ୟାଣ୍ଡି, କ୍ରିଷ୍ଟାଲାଇଜ୍ଡ ସୁଗାର, କନ୍ଦ ବା ଚିନିକୁ ଦୁଇଥର ସଫା କରି ତହିଁରେ ଶିରାକୁ ମାଠିଆରେ ବା ଥାଳିଆରେ ଢାଳି ରଖିଲେ କଣ କେତେ କାଳ ରଖିଲେ ସେଥିରେ ଥିବା କନ୍ଦ ଦାନା ବା ବଡ ରୁଆ ବନ୍ଧା ପାତ୍ରରେ ଉକ୍ତ ପାତ୍ରର ଗର୍ଭରେ ଲଟକା ହୋଇଥିବା ସୂତାର ଦେହରେ ବସିଯାଏ। ଏହାକୁ ମିଶ୍ରି ବୋଲାଯାଏ। ବୈଦ୍ୟ ଶାସ୍ତ୍ର ମତରେ ଏହା ସ୍ନିଗ୍ଧ ଧାତୁବର୍ତ୍ତ, ଦ୍ୟାଟ୍ ଇଜ ଦି ଟ୍ରିଟମେଣ୍ଟ। ଏଠି ଦେଖନ୍ତୁ ହିନ୍ଦୀରେ ଲେଖିଛନ୍ତି ମିଶ୍ରି। So ମିଶ୍ରି means it is a sugar candy, crystallizing sugar. Then what my I have not given that, but that it ଆମେ କୋଉଥିରୁ draw କରିଥିଲେ କି? Google definition about what is the rock sugar or crystal sugar. So what? ତାପରେ ଦେଖନ୍ତୁ ମିଶ୍ରି ସାର ସେଇ ଯୋଉ ଆମର ଯୋଉ ଇଏରେ ଅଛି ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ଭାଷା କୋଷରେ ମିଶ୍ରି ଦେଲା ମିଶ୍ରିତ, ତାପରେ ଆସିଲା ମିଶ୍ରି ସାର, ସିରପ ମେଡ୍ ଫ୍ରମ୍ ମିଶ୍ରି ସୁଗାର କ୍ୟାଣ୍ଡି। ଡେଫିନେସନଟା ଦେଖିବ। Then I've given definition in Chambers dictionary. Sugar, 1470 sugar. That may not be very much necessary because we are concerned about the confectionaries. My humble contention reading of all these things, in different places different names are being given and are being used. But in Odisha, if we refer to the Purnachandra Bhasa Kosha and all these things, this is prepared. It also described the process of preparation of misri. And ଚିନିଟା ପାଣି କରି ତାକୁ ପ୍ଲେଟରେ ପକେଇ ସୂତା ଦେଇ ତାକୁ ପିସ୍ କରି କାଢିକିରି ତାକୁ କରାଯିବ ଏବଂ that is used for the treatment of medicinal treatment also. My humble contention here in this case, it is purely for confectionery.
Sugar candy. MDY.
Sugar candy minerals have been defined.
Misri is known as sugar candy.
Minerals?
Misri is not known as sugar candy.
BC?
Misri.
No. Misri is not. Sometimes because what is happening? Somewhere else this is being used in local name else in local areas.
No. What is in this Odia dictionary? What they have stated? Misri. In Odia, what is
Misri?
What is the English name? What is it?
And
You are showing it. What is that? Book.
Sugar candy and crystallized sugar.
No, Misri आपण जो ଦେଇଥିଲେ definition ଟା
6-5-5-8 पेज टा पूर्णचंद्र भाषा कौशल जो citation ला ଦେଇଥିଲି last citation last but one page.
Reader. हाँ मिश्री केते नंबर एटा
मिश्री 6-5-5-8 मिश्री
हाँ 6-5 मिश्री हाँ
मिश्री मिश्र वासिंकट आसीथिला भारत रे या प्रस्तुत होतरा नाम शीतफला बड़ बड़ दाना रुआरे परिचित गुड़ सुगर कैंडी क्रिस्टालाइन सुगर
कोचिन सुगर कैंडी नुहे बोली
ना मु बोली सुगर कैंडी नो सुगर कैंडी कोठी ताको मिश्री ताको सुगर कैंडी कहउचंदी केठी ताको कहउचंदी कोन रॉक सुगर कोठी ताको कहउचंदी मिस्टी माने भिन्न भिन्न जगह भिन्न भिन्न लोकल नेम यूज होछि. That is what I refer to various judgments referring to that. That two matters may I point out here, paragraph 4 of the judgment. There also they refer to it is a sugar candy. Preparing of sugar candy.
Yeah. What is your submission to this?
Only matters. May I add another one and 2.5? Well, again, matters I will bring it to matters. Do the clause 3.
No. Have you just taken a plea or any material that in fact you are selling such thing?
No, there is no dispute on that. I have stated that is for the I am having running a factory. Also, the Misri factory.
Where have you stated so?
Matters?
Which evidence you have
Matters
adduced?
kind of matters my evidence matters I'm coming. Evidence stuff.
Have you taken a plea that it is for preparation of misery?
Yes.
Where is that?
Matters, the statement matters that is at page 21. Page 21 of the paper book matters. Statement of PW2 reveals that the said sugar in question was purchased by you from branch manager such and such, for which you failed to produce any license at anything and store the sugar in the godown such that the sugar in question was seized in presence of witness under exhibit 2 and by PW3. हाँ सत कथा मो जगह नथिला बोली मु सांतालिया ब्रदर्स गोदाम रखिथिली मु चीनी मिश्री तैयार करिया पई आनिथिली मु सब पैसा की देबी. That is the thing. Then, my lords, page 20, page 22, my lords, cross examination.
22.
My lords, just this next page. My lords, the accused has purchased the sugar to manufacture sugar candy in his factory. His factory is located in Meria Bazar, Kotak town. Of course, he is my relation, but he has told that he had kept those sugar in his godam as there was want of space in the house of the accused. Since the accused is his parental uncle, his obligation, he obliged him on the premises that he would remove it within a day. No rent was charged for storing of this sugar in his godam. Then, my lords, there is no other contention that I am. There is, but they seized the receipt I purchased. They have not seized any material to show that I was involved in selling of the sugar. That is what, my lords, I am pointing out again. My lords, I am requesting to my lords again to bring it the scope and objective of provisions of that clause 3 of the order.
Yes.
Clause 3, subclause 3. For the purpose of this clause in the sense clause 3, licensing of dealers. Clause, any person who stores sugar in any quantity exceeding 10 quintal at any time shall, unless the contrary is proved, be deemed to store the sugar for the purpose of carrying on business of purchase, sale or storage of sale of sugar. To that effect, there is no evidence. Even otherwise,
this clause means that even if you store sugar and that sugar quantity exceeds 10 quintals,
yes,
then it will be deemed that you are keeping it for
the
sale.
purpose of sale.
Exactly, deemed it for the purpose of this.
Contrary, that means owners then shifts to you.
The owner shift me.
That no, it is not for sale. It is for preparation of
that, or confectionery. That is what exactly, my lords, I am pointing out. Thing is that here in this case, if I would be keeping, my lords, all these things not for the purpose of, my lords, the confectionery, but for the purpose of sale and all these things, it onus lies on me to establish. Means that yes, I have kept it, I have used it, or I kept it for the use of the purpose. I have categorically stated this. This is not disputed, and I have a mystery factory. There is no material seized from me that I have sold this, and that is 100 quintal pre and post connection, my lords. 100 quintal. Subsequently, you have accepted. Before that, you have not accepted. There was no restriction or limitation of procuring 100 quintal or 200 quintal. There was no restriction in respect of bulk consumers. In respect of bulk consumers, the learned court categorically stated, brought me into the purview of mischief in the mischief on the ground that yes, I am coming within 3. Then, my humble contention is that all that whatever I have stated, that yes, it is for bulk consumer, and there is no material to show that I have used it for any other purpose. I have categorically stated that I have used it for the mystery purpose, and the mystery is being a confectionery. That is what, my humble contention, that there is no necessity of any license, because I am held up on the ground that I don't have a license. But on the other hand, the federation who has supplied me that on receipt, he got that license in the year 1890, though he sold me in the year 1986. I'm aged about 80, above 80. My lords. My lords, only wanted another.
Just. Yes,
I admitted that yes, I purchased it from the Consumer Cooperative Society. I admitted that I got it for my purpose of production of misri, and that too. And the very important is the evidence of page 25, evidence of Sarat Chandra Das, who was working as Inspector Vigilance. That page 25 points.
25. Yes.
Means cross-examination portion, my lords. Accused number 1. Page 26.
Yes.
He did not verify any document whether Santalia brother as a sister or concern of accused on Prakash Agrawal. But
which line you are placing?
Yes?
Which line you are placing?
Yes, last paragraph. So he did not. From last onward, 1, 2, 3, 4. He did not record any statement in this connection.
Which connection?
Well, that is relating to license that the Santalia brothers relationship with Santalia. That is not material. Thereafter, he cannot say whether any license is required or not for manufacturing of misri. And the accused owns misri factory inside the premises.
So, okay. So you mean to say that once you take a plea in your 313 statement, and some of the prosecution witnesses also lend corroboration to your accused statement, then you have discharged the burden of establishing your defense plea by preponderance of probability. So if that is discharged, then it is to be held that you are keeping it for that misri, and once it is misri, then no license is necessary. That is your contention. And because at that point of time,
I'm a bulk consumer. The
bulk consumer.
Even otherwise, my lords, aged about 80, more
than
84
My
years.
lords, may kindly come to page 12, the judgment part, which my senior was pressing. Wherein senior says that the court has concluded that he is a bulk consumer. That is not so.
That.
The lordship may kindly say.
I have not.
In this connection, assuming the accused number 1 to be a bulk consumer, even if assuming that he is a bulk consumer, even then he cannot store more than 10 quintals of 20 quintals as per subclause 3 of clause 3 of the Odisha Sugar Dealers Licensing Order.
No, why not? That amendment took place, that restriction took place. Perhaps he has not noticed that restriction came in 2/3/1990. How can he say that it is it's an error of record?
This incident has occurred in the year 86, my lords.
Right.
22/11/86.
That amendment came into force that he cannot keep more than
100
quintals. That is in 2A came into force in 2/3/1990.
Yes, my lords. 2/3/1990.
That means prior to that there was no such restriction.
No.
For the first time, so this incident took place in 86 or something like that. So this restriction is not applicable. This is an error of record.
Yes. And what's coming to that subclause 3.
Where is that line? Assume, where is that? You are
Page 12. Page 12. Last but one para. In this connection, the sentence starts with in this connection.
In this connection, yes. Assuming
the accused number 1 Assuming, my lords, assuming the accused number 1 to be a bulk consumer,
Uh,
even then he cannot store more than 10 quintals as per clause.
where from he got it?
Yeah.
This is error of record.
Yes.
This is this statute doesn't say so that you cannot keep. That provision came, perhaps he was holding a book where this bracket portion, and when it came to force, that he has not seen. Two-way, it would be like that. So he thought that, but he should have taken into account that when the occurrence took place and when this amendment came, this occurrence
took place in the year 86.
Right. So at that point of time, there was no restriction. Restriction came for the first time in 1990. So this goes, then sugar candy evidence is there. Take down. Hard the learning. This appeal has been filed by the appellant Om Prakash Agrawal. Challenging the judgment, challenging the order dated 7/5/1993 of the Learned Special Judge Cuttack in GR case number 72 of 1986. In finding the appellant guilty under Section 7 of the Essential Commodities Act for contravening the provisions of Orissa Sugar Dealers Licensing Order 1963, and sentencing him to undergo simple imprisonment for 6 months and to pay a fine of ₹1,000. In default, to undergo SI for 1 month. The prosecution case, in short, is that one Sri S.C. Das is PW. S.C. Das is PW3. PW3. Sarat Chandra Das.
PW3.
PW3. Inspector Vigilance CD Cuttack. The prosecution case, as per the written report submitted by Sarat Chandra Das, bracket PW3 Inspector Vigilance CD Cuttack, before the SP Vigilance Cuttack Division Cuttack on 2/12/86 is that he collected reliable information regarding clandestine business in sugar by accused number 1, Mesa Sankar Misri Factory. Therefore, he, along with Inspector D.B. Tripathi, D.B. Tripathi has not been examined.
D.B. Tripathi. No, D.B. Tripathi has not been examined.
Proceeded to the spot and traced out accused number 1.
He has been examined, man. Vanavasi Tripathi.
Vanavasi Tripathi has been examined.
Yes,
D.B. Tripathi.
D.B. Tripathi. D for Delhi, B for Bombay.
Paragraph 2.
No, my lords. Yes, no.
Not during Shankar Mistri factory. One Prakash Agrawal is the proprietor of Shankar Mistri factory, which is situated in Malgodown, Cuttack. Stop. When during inspection, the informant came to know that the accused number one, Prakash Agrawal, is the owner of a Misri factory in Meria Bazaar, who lifted 200 packets of imported sugar, Philippines, from Orissa Consumer Cooperative Federation, Malgodown branch, Cuttack, on 22/11/1986. Under receipt number 13183 dated 21/11/1986 for rupees 52,000, each packet weighed 50 kg. And stored those 100 quintals, stored the 100 quintals of sugar in Messrs. Shantolia Brothers, which is owned by the brother of accused number one, that is the appellant, right?
Yes.
When the appellant was interrogated, he denied to have purchased any sugar license for dealing with such purchase and storage. Accused number one, appellant. On verification of the shop of the appellant, Om Prakash Agrawal kiye chile gaya? Accused number one to?
Accused number one. Accused number one.
Okay. Accused number one likh to? On verification of the accused number two mane ki asla se jo ye
Branch manager.
branch manager. Well, accused number two ta likha idhar, so and so. He also, the informant also came to know that he didn't also have a valid license for carrying on business in sugar. And accordingly, first information report was lodged against both the accused for having contravened the provisions of Sugar Licensing Order 1963, punishable under Section 7 of the Essential Commodities Act. The defense plea of the appellant, who was accused number one, that he owned a Misri factory for which there was no necessity for having any license, and without any license, one can purchase 100 quintals of sugar, and he would come within the definition of bulk consumer. The defense plea of the accused number two that is the branch manager of Orissa Consumer Cooperative Federation Limited, was that he had a license for dealing with the sugar, and he has been falsely entangled in the case. Next para. The prosecution, in order to establish its case, examined 4 witnesses. PW1, Santosh Kumar Agrawal, is the nephew of the appellant, and he stated that the appellant had stored 100 quintals of sugar in 200 packets, which were imported from Philippines in his godown, known as Sonthalia Brothers, Messer Sonthalia Brothers, Malgodown, Cuttack. And the same was seized by the police, and it was kept in his Jima, as per Jimanama Exhibit 1, and he is a witness to the said Jimanam. PW2, Banavasi Tripathi, was the inspector of vigilance, and he stated to have accompanied Sarat Chandra Das, bracket PW3, inspector of vigilance, to Malgodown, Cuttack on 22/11/1986, and found the appellant was in possession of 200 packets of imported Philippine sugar, each containing 50 kgs. He further stated about the presence of appellant in the godown, and the appellant failed to produce any license or authority to purchase and store sugar in the godown of Messr Santhalia Brothers. He proved the seizure list Exhibit 2. PW3, Sarat Chandra Das was the inspector vigilance, Cuttack, and he, along with PW2, on receipt of reliable information of storage of 200 packets of imported sugar, in Sankar Mistri factory of Malgodown, Cuttack, proceeded to the spot and seized the sugar under seizure list Exhibit 2. And After preliminary inquiry, he submitted report to SP Vigilance. And then drew up the FIR, and on the direction of SP, stop. PW4, Nityananda Dalai was the Inspector Vigilance who registered the case against the accused persons under Section 7 of the EC Act for the contravention of Sugar Control Order. He stated to have seized the 200 bags of sugar and bills of the sugar from Orissa Consumer Cooperative Federation, Cuttack. He sees some documents from the Consumer Society from a dealership license of Consumer Society. Recorded the statements of the witnesses, and on completion of investigation submitted final form. From the defense side, no witnesses were examined.
No.
The defense has not examined any witness. The London Trial Court after analyzing the oral as well as documentary evidence on record, came to hold that from Exhibit A, it is crystal clear that Orissa Consumer Cooperative Federation Bhubaneswar, is declared as a licensee since 1989-90, and therefore the prosecution story that accused number 2 didn't possess any valid license for dealing with this sugar, completely falls to the ground, and accordingly they held that the prosecution is not able to make out any case against the accused number 2, Lakshmidhar Pradhani. However, the London Trial Court held that the appellant was found to have been in possession of 100 quintals of sugar. And since clause 3, since in view of subclause 3 of clause 3 of 1963 order, 1963 order, the petitioner was possessing more than 10 quintals of sugar, even if he is assumed to be a bulk consumer, he cannot store more than 10 quintals. And since the appellant was having no license, even though he was possessing 100 quintals of sugar, he can be said to have contravened the provisions of Orissa Sugar Dealers Licensing Order 1963. Mr. Danand Mahapatra and counsel, appearing for the appellant, contended that the restriction on all consumers not to keep sugar in excess of 100 quintals without the prior approval of licensing authority came into force by way of notification dated 2/3/1990, and prior to that there was no such restriction, and therefore the storage of 100 quintals of sugar on 2/12/1986 cannot be said to be any kind of contravention of any of the provision of 1963 order. The Land Council further argued that the defense plea is consistent that the petitioner, the appellant, was having a mystery factory, and mystery would come within the definition of confessional. And the definition of bulk consumer as per clause 2A indicates that confessionaries would also come within bulk consumer. And the appellant, being a bulk consumer and not a dealer, no license was necessary for preparation of misri, and therefore it's a fit case where benefit of doubt should be extended in favor of the appellant. Stop. Next para. Mr. M.S. Rizvi, an additional standing counsel for the Vigilance Department, on the other hand, supported the prosecution case, supported the impugned judgment, the findings of the London Trial Court, and submitted that since the quantity of sugar seized in this case is more than 10 quintals, and the petitioner and the appellant was having no license for such storage, we can be said to have flouted clause 3, subclause 3 of clause 3 of 1963 order, and therefore the appeal should be dismissed. Bulk consumer has been defined under clause 2A of 1963 order, which reads as follows, quote the entire thing. Therefore, confectionaries would also come within the definition of bulk consumer. Mr. Mahapatra drew the attention of this court to the to some citations where confectionery has been dealt with. In the case of Messrs. Perry and Company Limited versus Messrs. Perry and Company, reported in AR 1963 Madras 460. The division bench of the Madras High Court held. Which paragraph you are placing?
Paragraph 17.
In paragraph 17 as follows, quote in enter paragraph 17. In the case of Shadanand Khanchan versus State of Maharashtra, Division Bench of the Bombay High Court, reported in 1977 Criminal Law Journal. এটাকে 1341 It is held as follows. It is obvious এরকম এটা মার দଉଛି সেরকম করে দাও হ্যাঁ চাইনা বলবি In the case of Popu Sweets and Biscuits versus Commissioner of Trade Tax, reported in 1997 Supreme Court cases 228. Paragraph.
Paragraph minus 6 ର last portion.
6 ର
6 ର page 233 page ର second paragraph. The first paragraph and second paragraph.
Paragraph 6 ର
Paragraph 6 ରେ ଗୁଡେ subparagraph ଅଛି. Page 233.
233 ହଁ କୋଉଟା?
First paragraph ଟା second paragraph.
ଆଚ୍ଛା first paragraph ଟା ମାନେ
the word confects mean to put together from various material. Term confectionery, confection. Then ତା ତଳକୁ ରହିଲା dictionary.
এটা হইতে সে যে where coffee originated সেই পর্যন্ত এটা করবেন। The Land Counsel for the petitioner, the appellant, submitted that there cannot be any dispute that the misri or sugar candy would come within the definition of would come within confectionery, and thus it would come within the definition of bulk consumer as defined in clause 2 subclause A of 1963 order. If এটা কিন্তু স্টার্ট হয়েছিল সেন্টেন্সটা মিশ্রিটা লিখলে তো ওকে PW1 সেটা লিখুন PW1 has stated sub paragraph লিখুন that the appellant had purchased the sugar to manufacture sugar candy in his factory, and his factory is located in Meria Bazaar of Cuttack town, and he had kept this sugar in his godown as there was want of space in his house. The PW3, the inspector vigilance has also stated that the accused owns a mystery factory inside the premises, and he couldn't say whether any license is required or not for manufacture of mystery. Therefore, in view of the evidence of PW1 and PW3, it becomes clear that the appellant was the owner of a mystery factory. which is situated in, which is located in Meria Bazaar, and the accused had purchased the sugar for manufacturing sugar candy in his factory, and due to non-availability of space in the house, he has stored the sugar in the godown situated in Malgodown, Cuttack. In the accused statement also, to the question number 3 put by the London Trial Court, the appellant has taken a specific stand that he had purchased the sugar for preparation of misri, bracketed sugar candy liquid. An accused is not required to prove its case beyond all reasonable doubt, but can establish his defense plea by preponderance of probability. When his plea is supported by 2 of the prosecution witnesses and the prosecution has failed to prove any contrary evidence to that effect, the defense plea is acceptable. Now the question crops up for consideration as to if the accused was keeping the sugar for preparation of misri, bracketed sugar candy, on 22/11/1986 in store at Malgodown, whether he was required to obtain any license as mentioned in clause 3 of subclause 3 of clause 3. Or he being a bulk consumer is not required to have a license as per the said clause. Clause 3 of 1963 order deals with licensing of dealers, and it states inter alia that no person shall carry on business as a dealer except under and in accordance with the terms and conditions of a license issued in this behalf by the licensing authority. Stop. Licensing authority has been defined under subclause C of clause 2. Stop. Subclause 3 of clause 3 of 1963 order states that any person who stores sugar in any quantity exceeding 10 quintals at any one time shall, unless contrary is proved, be deemed to store the sugar for the purpose of carrying on the business of purchase, or sale, or storage for sale, of sugar stock. In other words, if sugar in excess of 10 quintal is seized from a person who has stored the same, it is to be deemed that he has kept it for business purpose, that is for or for sale, and the contrary is to be proved by the accused that it was not meant for business purpose or sale. Since it has already been held that the sugar kandi or misri, being the confectionaries, would come within the definition of bulk consumer, it is to be seen whether there is any kind of restriction on the bulk consumer. The London Trial Court has relied on the provision under Section 2A in the impugned judgment and held that even if it is assumed that the appellant is a bulk consumer, he cannot store more than 10 quintals as per subclause 3 of clause 3 of the Odisha of 1963 order. Stop. The restriction under 2-A of 1963 order came into force on 2/3/1990, which reads as follows, quote 2A. On a plain reading of the clause 2A, it would be apparent that if a bulk consumer stores sugar of 100 quintals or less in any calendar month, then there would be no necessity of obtaining prior approval of the licensing authority. Only in case the quantity of sugar exceeds 100 quintals in any calendar month, storage of sugar storage of sugar exceeds 100 quintals in any calendar month, then it has to be with the prior approval of the licensing authority. Otherwise, you would be liable to pay penalty as mentioned in the said clause 2A. The restriction of 10 quintals as mentioned under subclause 3 of clause 3 in 1963 order is meant for the dealers. In other words, if somebody is a dealer and not come within the bulk consumer, he is to obtain license to carry on his business as a dealer. And in case of bulk consumer, if he wants to keep in excess of 100 quintals, then he has to obtain approval of the licensing authority. In the case in hand of para, since the defense plea that the sugar of 100 quintals was kept by for the confectionaries, purpose of confectionaries, and it comes within the definition of bulk consumer. And there was no restriction of any quantity of storage for the bulk consumer on the date of occurrence. I am of the view that it cannot be said that there was any contravention of the provisions of subclause 3 of clause 3 of 1963 order by the appellant in possessing 100 quintals of sugar without any license. Therefore, the conviction of the appellant under Section 7 of the Essential Commodities Act is not sustainable in the eye of law, and the same is hereby set aside. Criminal appeal is allowed. Yes, anybody else is there?
Mention item number 40.
Item
number 40.
What is your item?
89.
Oh, 89 is.
I am for the respondent.
Okay. What is that?
I am 89.
89. What is that matter? 89. Huh?
I have been acquitted. Against that, the government has filed the appeal.
89.
89. I am suffering due to.
Just a minute.
I am now getting salary, my lord.
GCRLA.
Yes,
It's a vigilance case. So,
yes.
Mr. Sangram Das will be conducting this matter. I will inform you if your lordship says.
what is this trap case?
Yes, ma'am. 400 rupees only trap.
So, the decoy and overhearing witness, have they supported the prosecution case?
No, they are not supported. I am that is why I am acquitted, my lord.
So, you ask Mr. Da, it will be taken up next week then. Huh? What is your item?
Item number 40.
What is that matter? 40 is?
That's also a trap case, my lord. I was a doctor alleged to have taken, my lord, 400 rupees.
Yes.
I have been convicted, my lord. It's an appeal. My learned friend is doing.
What is that decoy and overhearing witness, they supported the prosecution case?
My lord, the complainant has turned hostile. But the learned lower court has proceeded with the fact that the other, as your lordship said, the other witnesses, accompanying witnesses,
okay,
they have confirmed that the complainant, before the pre-trap meeting, has reiterated that a bribe was asked, and hence he went.
It was recovered from your possession.
It was not recovered from my possession. It was recovered on the table, of my table, and the witnesses along with the IO.
What is your defense plea?
My lord, my defense plea is twofold, my lord. Number one, I had never. My lord, twofold, my lord. Number one, I have never demanded, because, my lord, the allegation was that the complainant had a my lord, quarrel. He had some injury. He went to the police to file an FIR. Police sent him to the hospital for injury report. Now, my case is I have sent the injury report on the same day, and that has also been verified in a cross examination. Now, but
no, let us see. Where is your accused statement?
my lord,
Accused statement in paper book, page number, paper book.
May I be pardoned, my lord, the paper book is not available right now with me. My brain's matter may be taken up any other.
Just a minute. Let me see that.
Page 44.
Come to page number. No. Come to the last question.
Yes, ma'am.
Read out. Do you want to say anything more about this? Read out what he has stated. Rajendra Bhai.
Rajendra Bhai, Tumbo
Nathar
boys or rehabilitation or resettlement determination
No, this is ଅଗ୍ରାହ୍ୟ ହୋଇଥିଲା ମୁଁ ସେଥିରେ ଜଣେ ମେମ୍ବର ଥିଲି ଏଣୁ ଗୋଟିଏ ମିଛ କେସ୍ ହେଲା so you are taking a plea that what about this thing ଆପଣ ଯୋଉ ରିକଭରି ହେଲା କଣ କହିଲେ ଆପଣ
I have recovered my mo table lu hela how this the solution also did not change in my lord. Then the lower court has relied on the CE report to say that CE report says that there were some changes.
Question number 14 person. It further transfers that when you denied to have demanded and received the bribe amount,
my lord,
a search was conducted as per the version of the complainant and his brother.
Yes, madam.
And the tainted GC notes were recovered from inside the table calendar kept
on your
office table. And the official witnesses compared the so-and-so and initials which tallied with their earlier noting. Tomka Jabot Karaita. That means you are admitting also that the notes were tainted notes were recovered from inside the table calendar.
Yes, the table calendar kept on the table.
Kept on the
yes,
table.
not from a drawer or anything.
No. ସବୁବେଳେ ସବୁ ଟଙ୍କା ଡ୍ରୟରେ ରଖାଯାଏ ଟଙ୍କା ନେଲା ପରେ କେତେବେଳେ ପକେଟ ରଖାଯାଏ କେତେବେଳେ ଆଲମିରା ରଖାଯାଏ କେତେବେଳେ ଡ୍ରରେ ପୁରା ହେଇଯାଏ ତେଣୁ ଆପଣ ଏଠି ଡିସ୍ପ୍ୟୁଟ କରୁନାହାନ୍ତି ଯେ ଟଙ୍କାଟା ଆପଣଙ୍କର ଟେବୁଲର ଏ ଯୋଉ କ୍ୟାଲେଣ୍ଡର ତଳୁ ଯିବ ଏଇ କ୍ୟାଲେଣ୍ଡର ତଳେ ପୁରା ହେଇଛି ହେଲା tainted GC notes were recovered from inside the table calendar.
Yes, ma'am.
So now you are to say when you are not disputing the recovery part.
Yes, ma'am.
Then the next things comes about acceptance and first is demand.
Yes, ma'am.
So acceptance upon kon koile. What is the evidence of acceptance? As complainant so and so you are demanding ta koile janini.
Well, on the recovery,
ଆପଣ क्वेश्चन नंबर 10 onward ସବୁଡା true କହୁଛନ୍ତି
ଆଜ୍ଞା
ଯେ ସିଗ୍ନାଲ ପାଇଲା ପରେ ଟ୍ରାପ୍ ପେଟି ମେମ୍ବର୍ସ ମାନେ ତମ ଅଫିସ ରୁମ କୁ ଆସିଲେ ତମେ ସେତେବେଳେ ଅଫିସର ଚେୟାର ରେ ବସିଥିଲ ହେଲା
ଆଜ୍ଞା
କମ୍ପ୍ଲେନାଣ୍ଟ ବି ଥିଲା ତା ଭାଇ ବି ଥିଲା ସେ ଏଣ୍ଟ୍ରାନ୍ସ ଡୋର ପାଖରେ ଛିଡା ହେଇଥିଲେ କଣ ନା କ୍वेଶ୍ଚନ ନମ୍ବର 10 ର ଆନ୍ସର ଟା ହଉଛି true. Then further it transpires that after getting confirmation from the complainant and his brother and accompanying witness, the trap party member challenged you to have demanded and accepted the bribe amount from the complainant, which you denied the same. Upon manna kare na true.
Yes.
Hala? Further it transpires from that the informant kept the demanded amount on your table as per your direction, and thereafter you wrote down the medical certificate and handed over the same to the informant. It further transpired that your hand wash was taken and tasted in solution of sodium carbonate, and there was no change of color of the solution, and the samples had been preserved in the so-and-so too. It further transpired that when you denied to have demanded or received I was seized in presence of a wash of calendar frame inside was taken in solution of sodium carbonate, which turned to pink. Yes. ତାହେଲେ ଆପଣ ସେତେବେଳେ ଆସିଷ୍ଟାଣ୍ଟ ସର୍ଜନ ଥିଲେ ପ୍ରୋଜେକ୍ଟ ହସ୍ପିଟାଲ ଖଟିଗୁଡାରେ ଇନ୍ ଦି ଡିଷ୍ଟ୍ରିକ୍ଟ ଅଫ ନବରଙ୍ଗପୁର। ସେଇ ସମୟରେ ଗୋଟେ ଇନସିଡେଣ୍ଟ ହେଲା, ସେ ଇନସିଡେଣ୍ଟ ର ଡେଟ୍ ହଉଛି 23/8/1998। ତ ତା ଦେହରେ ଇନଫର୍ମାଣ୍ଟ କୁ ସେ ଯେତେବେଳେ ଖଣ୍ଡିଆ ଖାବରା ହେଲା ଏବଂ ଖଟିଗୁଡା ଥାନାରେ ରିପୋର୍ଟ ଦେଲା, ସେତେବେଳେ ତାକୁ ପୋଲିସ ରିକ୍ୱିଜିସନ ରେ ପ୍ରୋଜେକ୍ଟ ହସ୍ପିଟାଲ କୁ ପଠାଗଲା ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ,
ଆଉ ଏକ୍ସାମିନେସନ
ମେଡିକାଲ ଏକ୍ସାମିନେସନ ଆଣ୍ଡ ଟ୍ରିଟମେଣ୍ଟ ବୋଥ। ସୋ ସେଇ ପରିସ୍ଥିତିରେ ଇନଫର୍ମାଣ୍ଟ ର କେସ୍ ହଉଛି ଯେ ପୋଲିସ ରିକ୍ୱିଜିସନ ରେ ଆସିଥିଲେ ମଧ୍ୟ ଆପଣ ତାକୁ 500 ଟଙ୍କା ମାଗିଲେ ଲାଞ୍ଚ ହିସାବରେ ଯେ ତାର ଚିକିତ୍ସା କରିବା ପାଇଁ, ଆଉ ପ୍ରଥମେ 100 ଟଙ୍କା ମାଗିଲେ
ନେଲେ,
100 ଟଙ୍କା ନେଲେ ଏବଂ ବାକି ହଉଛି 300 ଟଙ୍କା 1998ରେ
ଟ୍ରାପ୍ କେସରେ
ଦବା ପାଇଁ ଆପଣଙ୍କୁ ସିଏ ଦାବି କଲା, ଯାହା ପରେ ଆପଣ ଆସିକି ତାକୁ DSP ଭିଜିଲାନ୍ସ ଜୟପୁରରେ ତାକୁ ରିପୋର୍ଟ କଲେ ଏବଂ ସିଏ ଆସିକିନି ଅଭିଯୋଗ କଲା ଯେ ଆପଣ 300 ଟଙ୍କା ମାଗୁଛନ୍ତି ଏବଂ ତାପରେ ସେ ପ୍ରିପାରେସନ ହେଲା, ସେ ଫେଲନ୍ଥଲ ପାଉଡରରେ ସବୁ ଟ୍ରିଟମେଣ୍ଟ କରାଗଲା ଏବଂ କମ୍ପ୍ଲେନାଣ୍ଟ କୁ ହ୍ୟାଣ୍ଡ ଓଭର କରିଦିଆଗଲା ସେ ଟଙ୍କା, କରେନ୍ସି ନୋଟ୍ସ, ଏବଂ ତାକୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଦିଆଗଲା ଯେ ଓନ୍ଲି ଅନ୍ ଡିମାଣ୍ଡ ଆପଣଙ୍କୁ ସିଏ ଦବ ବୋଲି। ଦେନ୍ ତାପରେ ଟ୍ରାପ୍ ପାର୍ଟି ବାଲା ସବୁ ଅଲଗା ଅଲଗା ଜାଗାରେ ରହିଲେ, ସିଗ୍ନାଲ ଆସିଲା ଯେ ଆପଣ ଆକ୍ସେପ୍ଟ କରିନେଲେ ବୋଲି।
ସେଇ ଯୋଉଟା ସିଗ୍ନାଲ, that's also my lord, the accompanying witness has said that he did not enter the room, only the complainant and his
who is the complainant?
My lord, the complainant is my lord
PW3.
No, my lord, the PW3 is the accompanying witness. Complainant is Gajendra Nayak, my lord. He is the
PW5.
PW5. So my lord, PW5 and my lord read that letter where I say that the rehabilitation committee ମୁଁ ତାଙ୍କ ଭାଇଙ୍କୁ ମନା କରିଥିଲି ଏଜ ରେ, ସେମାନେ ଦି ଜଣ ଆସିଲେ, କିନ୍ତୁ accompanying witness has said that I was not
PW3 ତ
नहीं sir, PW5
PW5 ର paragraph 2 ରେ ସିଏ ସେ ଟ୍ରାପ୍ ଫ୍ରାପ୍ କଥା ଛାଡନ୍ତୁ, ସେ ଡିମାଣ୍ଡ କଥା ଛାଡନ୍ତୁ, ଘଟଣା ଦିନ ଯୋଉ ଆସିଲା
ଆଜ୍ଞା
ପ୍ରିପାରେସନ କଥା କହିଗଲା।
ଆଜ୍ଞା
ତାପରେ ସେ କହୁଛି
ଆଜ୍ଞା
thereafter myself and my brother
ଆଜ୍ଞା
Kumbeswara
ଆଜ୍ଞା
went to Khatiguda hospital,
ଆଜ୍ଞା
and after reaching Khatiguda hospital I put the said notes on the table of the accused doctor.
accused doctor, yes. I kept the money as per the instruction of the accused doctor. So in cross examination, however,
Wait.
yes.
Then he says again, I kept the money. Okay. I kept the money as per the instruction of the accused doctor.
Yes, my lord.
Okay.
Last
Then
line of the
thereafter
paragraph.
some officer came, asked the accused as if he has received the money from the complainant or not. At this, the accused doctor told the vigilance inspector that he received money from me to issue medical certificate. Thereafter, vigilance inspector seized the notes from the table
Yes, from the table.
of the accused and went on typing papers.
Aye.
I signed the said so and so. ताମାନେ ସିଏ ଇଏ ଧରିଥିବା କଥା ବା କାଉଣ୍ଟ କରିବା କଥା କିଛି କହୁନି,
କିଛି କହୁନି
ଖାଲି କହୁଛି ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଲେ
ମୁଁ
ସେଥିପାଇଁ
ରଖିଲି।
ମୁଁ ତାଙ୍କ ଟେବୁଲ ଉପରେ ରଖିଲି,
ଆଜ୍ଞା
ଏହା ତ କଥା।
ଆଜ୍ଞା
ଓକେ, ତାପରେ ତାକୁ ହୋଷ୍ଟାଇଲ ଡିକ୍ଲେୟାର କରାଗଲା।
ଆଜ୍ଞା
ହୋଷ୍ଟାଇଲ ଡିକ୍ଲେୟାର କରାଯାଇ ପ୍ରିଭିୟସ ଷ୍ଟେଟମେଣ୍ଟ ତାକୁ କନଫ୍ରଣ୍ଟ ହେଇଛି।
ଆଜ୍ଞା
କନଫ୍ରଣ୍ଟ ହେଲା ପରେ
ସେଭେନ୍ଥ ଆଜ୍ଞା ପାରା ସେଭେନ୍ଥ
ପାରାଗ୍ରାଫ 10
10ଟା କ୍ରସ୍ ଏକ୍ସାମିନେସନ
10 ର ସେ ଯୋଉ ଲାଇନ ଟା ଅଛି ଇଏ କର ହେଲା।
accused did not charge
The
me any money
accused
for my
did not
treatment
charge any money for my treatment,
and though I did not
I
pay
did
money
not pay any money
Hmm.
and treated me, discharged me
from the hospital. Yeah.
Okay. In my presence, the vigilance was not okay.
My lord, ଆଉ ଗୋଟେ ଖାଲି if your lordship are reading, my lord, ସେ ପାରା 3 ରେ ଯୋଉ my lord ପଢିଲେ, my lord, may kindly see para 3 at the time your lordship read, at this the accused doctor told to the vigilance he received money from me to issue a medical certificate. My lord sees, my lord, the entire, my lord, I'll try and state, my lord, how the lower court has confused between medical certificate and injury report.
Just a minute.
Again.
At this, the accused doctor told to the vigilance inspector that he received the money from me to issue a medical certificate.
So, as your lordship knows, it was sent by police requisition.
Okay, what the overhearing witness has stated?
Yes, my lord. My lord, may kindly, my lord, come to PW3, page 54, man. Shall I place, my lord?
ଏଗୁଡ଼ା କଣ ଏମିତି ଲେଖା ହଉଛି ଏଇ ଯୋଉ ଏକ ଏମିତି ଏଟା ପେପର ବୁକ୍ ଏଟା ଲେଖା ହବା କଥା PW1 PW2 ଏଟା ହଉଛି PW3 ତାକୁ କରେକ୍ସନ କରିବ। Yes, କଣ ହଁ
Shall I read, man? On 14/9/98.
You just come to that relevant portion. Say ଛାଡି ଦିଅନ୍ତୁ ସେ ଯୋଉ trap pre-trap ଯାହା ହେଇଛି ହେଲା
मतलब ଦୁଇଟା ଦେଖନ୍ତୁ para 2 ଟା after therefore after the aforesaid instructions were given
we all proceeded to
yes we proceeded to Khatiguda myself and the complainant went to Khatiguda hospital. After reaching Khatiguda we found the accused doctor was sitting in his chamber and seeing the accused the complainant kept the aforesaid tinted GC note on the table of the accused and came and told me that he kept the money on the table of the accused. At this, I gave the pre-arranged signal, and getting my signal, other witnesses and vigilance officers rushed to the spot. After reaching the spot, the vigilance officer caught hold of the hands of the accused and recovered the tinted GC notes from the table of the accused. The money was found below a calendar. The vigilance officer seized the note.
No, just a minute. We found that the accused doctor was sitting in his chamber. Okay.
Yes, madam.
Seeing the accused, the complainant kept the aforesaid tinted GC notes on the table of the accused
and came and told
me that he kept the money on the table of the accused.
My lord, may kindly note came and told me. Then I'll say why he says came and told me, my lord, in cross-examination. Came and told me that he kept the money on the table of the accused.
Just this man has not been declared hostile.
No, my lord. But my lord, may kindly see para 3.
Para 3.
Yes, ma'am. The complainant, along with his brother, the same brother, my lord, entered inside the room of the accused, and I remained outside the room. I cannot say anything in what manner the money transaction relating to the aforesaid tainted GC notes happened in the room of the accused, as I was present in outside of the room. That's why, my lord, there he says, came and told me. When the vigilance officer asked the accused if he has received the money, the accused told that he neither demanded the money or to the complainant, nor the complainant offered money to him. The hand wash of the accused in chemical solution was not taken by the IO after recovery of the tainted GC notes. It is not a fact that the complainant has told nothing before me regarding seeking. So, my lord, it is clear that he never went into the room. So, my lord, there is no independent corroboration to the fact after the main complainant has turned hostile that there was a demand and the money was given pursuant to the demand.
Your hand wash did not change color.
In naked eye, it did not, my lord. So I must tell you fairly, my lord, the lower court has relied on a chemical examination report to say that any chemical examination report says that there are some traces. Now, my lord, I'll show your lordship judgment, my lord, especially when it is being kept on the table. There is a judgment which says there are chances of because it did not turn the colored solution did not the solution of the did not turn colors in naked eye. There is chances of the traces being found because it's on the table. But everybody has said so, man. All the witnesses, nobody has said that it has turned.
Where from the recovery was made actually?
On the table, man. On the table.
On the table or below the calendar?
Man, they say, man, some say there is a calendar frame. Man, so it's very difficult. There's triangle calendars as well. So they are saying calendar frame because man, remembers it says that when the calendar frame was put it in the solution, it turned. The color turned. Now, my lord, he never says that I put it.
That calendar has been marked as an exhibit.
Now, my lord, the calendar.
Let us see that
frame. My lord.
Must have been marked as an MO6 is that calendar.
Yes, ma'am.
So it is marked as an MO. So
MO6, yes, ma'am. Calendar. So, my lord, if I would have touched it and
kept... It will be hard. I'm making it part hard so that it will come in the top. Hard in part, during course of argument, necessity is felt for verification of the original trial court record as well as the material objects. Let the Register Judicial intimate the Lenin trial court to send the same immediately so as to reach this court on or before 1st of August 2023. Hard in part for them. And who will argue this matter?
No, sir, I will.
Okay. You get your paper book.
I will.
Fixing on a date, madam.
It is fixed to. It will come 3rd of August 2023 as part hard. Okay, in the top of the list.
Gratefully.
Oh. 89. Yes, you will also prepare in that case, but I will take up in that first one.
That 89 item needs to be conducted by Mr. Sangram Das. It's not my assignment. So I will inform you.
Okay, Seitabu Kordiantu.
Yes, sir.
That is an acquittal order, no? So keep it as item number 2 also. But acquittal is.
Yes, ma'am.
Acquittal is upon pushing the hard in part for the. All right.
Well, these both items will be listed on 3rd of August.
3rd of August in the weekly list it will be there, item 1 and 2. And this matter would be item number 1. And his matter would be item number 2. Both will be partnered. And you want the name of Mr. Sangram Das to be reflected in the cause list.
Yes.
In the item number 2, Mr. MSD Learned Council submits that the matter is to be argued by the on the side of the vigilance by Mr. Sangram Das Learned. It's there, Mr.
Great.